Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now join here and will be heard. God save the United States and this honorable court.
Please be seated. Welcome this morning. Welcome, Judge Kelly. Always good to see you. Can you hear us?
Barely.
Oh, okay, there. Just couldn't hear you at first. We have 6 cases on our docket this morning. I left my glasses in our conference room.
Should we take a break?
Can I be excused for a minute, please?
Is it okay if I get started? We got a nice crowd here this morning. Glad you could join us. This courtroom's a lot of people's favorite courtroom in the building. We have 4 very distinctive courtrooms.
I also left my card to get that. Judges get excited too and forget things, but we'll make up the time by taking 5 minutes off the time for each of them. So we have 6 cases on our agenda today, 5 for oral argument. We'll start with 25-9523, Frontier Airlines versus Department of Homeland Security. Mr. Feinberg.
Good morning, Your Honors, Counsel. May it please the Court, Adam Feinberg on behalf of Petitioner Frontier Airlines. The main issue in this case is whether a user fee statute authorizes TSA to obtain a fee when there is no user. It does not. The fee instructs TSA to impose a fee on passengers who take a trip in air transportation to pay for certain TSA costs of providing aviation security services, all of which are specific to airports and flights. In this case, the customers canceled their tickets before flying and thus never became passengers, never took a trip, never engaged in air transportation, and never received any security services from TSA. Based on an argument Mr. Shaw and I had 2 weeks ago in the Fifth Circuit regarding essentially the same issue, I expect that he will tell you that TSA concedes that an individual who doesn't travel does not incur a fee. Instead, TSA tries to justify its position in this case based on 2 arguments. First, it says Frontier has no statutory authority to keep the funds at issue. But that's totally irrelevant. The question here has nothing to do with Frontier's statutory authority. It's whether TSA has statutory authority to keep the funds at issue, and it does not.
Well, the statute says that Frontier is to remit collected fees at the end of each month. Why doesn't that cover the procedure that they're advocating?
Right, that's exactly TSA's second argument, but there's a whole host of reasons why that's not the case, and I'll sort of go through them. First, just starting with the text of the statute, that's not quite what the statute says. It says that a fee has to be remitted if there's an incurred fee. And I think TSA's argument is premised mainly on subsection E1, which speaks of fees imposed and amounts collected under this section. But I think the only way to read that phrase is that the amounts need to be both a fee imposed and an amount collected under this section in order for it to be triggered. Because otherwise it doesn't make any sense. That provision says that those things, fees imposed and amounts collected, must be given to the administrator of TSA. Well, a fee incurred that is not collected doesn't go to TSA, at least not in the first instance. It goes from the passenger and to the airline. So
Frontier would collect the fee when it sells the ticket to its customer, right? And
Correct.
And then you put it in your TSA account.
Correct.
Is that fee then transmitted to TSA at the end of the month, even if the passenger hasn't flown yet? And if the passenger, that's question one, and then just if that's correct, then does Frontier get the claw back the fee when a passenger doesn't fly, or gets a travel credit by just offsetting a future deposit in its TSA account? Is that how it works?
Yeah, more or less, that's correct. The amount has to be paid to TSA at the end of the following month. And in this particular case, all but one of the fees were never given to TSA. So there probably will be some talk about the refund provision, but the refund provision is totally irrelevant because these amounts were never given to TSA because the passenger decided not to fly before the amounts were given to TSA. So at that point,
Well, did Frontier collect the fund from the passenger who decided not to fly?
correct, Frontier initially collected that amount, but
And if they give it all back to the passenger, there's no problem, correct?
correct. TSA can.
Okay, why should Frontier be allowed to keep the $5.60 if the ticket is just totally canceled and there's no refund?
Well, first of all, we do argue that there is a valid refund, but that's a separate issue. The reason is because TSA has no statutory authority to ever receive a fee if the passenger doesn't travel. Frontier, on the other hand, is governed by its contract of carriage with its passengers, which explicitly says Frontier is entitled to those funds. So this would be a windfall to TSA because no one travels. TSA concedes that no fee has been incurred, yet TSA wants to keep the fee even though no passenger has traveled.
Well, the language fees imposed and amounts collected has been troubling me, and it was not addressed in your brief. I thought you made a decent argument just now about what it means, but it seems...
Excuse me, Judge Harris.
Yes.
Arts, can you please speak to your microphone?
Yes, sir. He's been my senior for so many years in many different capacities, so I always do what Judge Kelly tells me to. I'll try to comply. Sorry.
Thank you. Thank you.
But it seems that the fee is imposed and the amounts are collected when the ticket is sold. The fee is imposed at that point, amounts collected, and then those funds are payable to TSA, essentially. If the person doesn't travel, then Frontier, if it's before Frontier's remitting the amounts collected, then Frontier just doesn't send that on. But if it is sent on, then TSA, ordinarily, I would hope they have the authority to refund it. But as with many intermediaries, they're not going to refund it to the intermediary unless the intermediary is going to refund it to the passenger. Why isn't that a natural reading of that section, E1?
Well, I think there's several problems with that. First of all, the fee isn't actually owed at the time the ticket is sold. TSA says that
We're talking about fee imposed. It's definitely been imposed at the time that the ticket is paid for, is it not?
Well, I would argue no, it's not imposed until there's actually a passenger who engages in air transportation. It happens to be collected because TSA has told everybody, this is in their letter at AR3, that they want airlines to collect and remit based on when the ticket is sold. But that's not what the law says. We go over this a lot in our opening brief. There's no obligation to collect or remit until the passenger gets on the plane under the statutory scheme. But I think there's a bigger point, Judge Hartz, which is there are lots of other provisions, particularly in the tax code, that have very similar provisions that say you have to collect and remit. The air transportation excise tax that's at issue in a bunch of the cases the government cites says that. And if you look at the Cockey decision from the Seventh Circuit, the very first paragraph talks about these are the provisions that are at issue in the excise tax, and it says the airline must collect and remit. But then there's a separate provision in 6415A that commands the result that TSA wants in this case. And so under the reading you just described, Judge Hartz, that provision, 6415A, would be either that would be superfluous or the collect and remit obligations would be superfluous because you'd have the same result without section 6415A. And the Supreme Court in the Jefferson Electric Manufacturing case makes the same exact point. It says there's a statute that specifically says you have to give the money back to the customer, but before that, the collector could get a refund even without that. And so the general rule that TSA is arguing for, that you can never keep the money as the collector, doesn't exist unless there's a specific statutory provision that says that, as there is in a handful of provisions in the Internal Revenue Code. But there isn't one here.
Let me ask a more general question to put this in perspective. What is the rationale for Frontier not to refund the entire ticket price when a flight is canceled? I'm not just talking about this fee, but why not refund all of it?
Well, I think that...
So I buy a ticket, it's a $200 ticket, $5.60 tax here, whatever the amount is. You don't take the trip. Why doesn't Frontier, just as a matter of course, then refund the entire money? What's the rationale for not refunding the money?
Well, it's just a business decision. They can strike whatever bargain they want with their customers, and they're able to offer a cheaper fare up front if they offer a ticket that has more limited refund rights.
There's no business reason? It's not because of the cost of processing this or something like that? They just decide, okay, this is a way to get some extra money?
Maybe I'm misunderstanding your question. Do you mean for this particular fee or for
any
just
fee,
in general?
For not refunding in full the price of the ticket when someone cancels. I assume it's because there are administrative expenses in doing this.
Well, for sure there are. Maybe I misunderstood your question, Judge Hartz. And I think it's important to keep in mind too, so you have a ticket that is going to be refunded just the airfare via this credit. And so everything else has to follow suit or it's chaos. So there's not just the TSA fee, but there's a federal excise tax. There are some other fees like passenger facilities charges. If everything didn't follow suit, you might have a situation where Frontier had to send refunds to different people in different forms, which is administrative chaos. Take this, for example. So TSA in its letter in 2002 says the money has to be refunded to the ticket purchaser. But in 2020, their guidance says it has to be refunded to the passenger. Well, what if those aren't the same person? Like I buy a ticket for my wife. It's totally unclear who TSA says the money should go to. Well, imagine then if the IRS, airport authorities who control the passenger facilities charges, customs, which has their own user fee, all had different rules and said, well, you have to refund in this form or that form. It's totally unworkable from the airline's perspective.
What about the provision that says no portion of the fee collected under this section may be retained by the air carrier, et cetera, for the cost of collecting, handling, and remitting the fee
I think,
for the interest accrued.
yeah, I think that's addressing a very specific scenario of you cannot keep Frontier a portion of the 560. And there's a lot of context for that. The passenger facility charge, for example, says airlines get to keep 11 cents out of the $4.50 for that particular fee. And so all this is saying is if a fee is owed, you got to give the whole 560. You can't keep a portion of it. But here, the fundamental problem for TSA is there was no fee incurred. And if there's no fee incurred, they are simply never entitled to obtain the funds. There's no statutory authority for that. And this is exactly what the court in a Court of International Trade held in the similar Southwest case, that these administrative provisions about collection and remittance simply cannot override the general authority provision in subsection A that says when TSA is entitled to a fee.
You've raised a kind of subtle issue. You talked about the fee incurred. E1 talks about the fee imposed. Is it imposed at the time that the ticket is sold, but it's not incurred until the passenger travels? Could that be how to read E1?
I don't think so, because you'd have the same problem that I mentioned before about E1. Because from the passenger's perspective, the passenger never owes anything to the TSA administrator. So I think you have to be talking about things that are both owed under the statute, and so subsection E2 talks about the collection obligation on the airline is for things that are incurred under the statute. That's the only thing that needs to be collected. And I don't know if you have any follow-up, but I'd prefer to reserve the rest of my time for
Any questions,
rebuttal.
Judge Kelly?
I have no further questions. Thank you.
Thank you.
Thank you, Your Honor.
Good morning, and may it please the court, Whaley Shaw for TSA. I'd like to start with the statutory text and specifically the provisions in E1, E3, and G. I think the way that Mr. Feinberg would read E1 would completely make the amounts collected provision superfluous. But I think the more natural reading of that provision is it actually does mean all amounts collected, and that's consistent with the provision in G. And the reason is that it is, as Congress recognized specifically and expressly in subsection G, it is possible for a fee to be properly collected and yet no longer owed at some later point in time. And so what E1 says is that even those amounts must be remitted to TSA. But then Congress also enacted subsection G to govern how those over-collected or overpaid amounts should be dealt with. And I would also specifically note that in contrast to Mr. Feinberg's argument, subsection G actually refers to all amounts paid, fees paid in excess, which indicates that the trigger for subsection G is not the remittance of the fee from the airline to TSA, but rather the payment of the fee by the passenger. So as soon as the passenger pays the fee, TSA has the authority to refund it. And that also makes sense because the statute and regulations make clear that the fees that the airline collects are held in trust for TSA, and the airline has no legal or equitable interest in those funds.
So is TSA refunding the fee to non-travelers?
TSA has designed a refund procedure that is designed to accomplish exactly that, which is that it directs airlines to refund the fee to non-traveling passengers, and then it reimburses the airlines for giving that refund. Now, the problem here is not that TSA does not want to refund those passengers. The problem is that Frontier was supposed to do that and collect the money back from TSA.
Well, if that's the economic reality of it, why not let Frontier just hold on to the fee and let's see if the customer travels. If he doesn't travel, then the TSA doesn't need to then refund money back to the airline. That seems like a completely wasteful step. And And then TSA doesn't have to keep track of who's going through the turnstile at airport security.
So let me be clear, that does happen, and that it can be the case that the fee never actually reaches TSA's accounts, but is refunded directly from Frontier to the passenger. And that, again, is consistent with subsection G, because as I was saying, the TSA's authority to refund the fee starts upon payment of the fee by the passenger. So if Frontier has collected the fee but has not remitted it yet if Frontier has collected the fee but has not remitted it to TSA, TSA can nonetheless authorize a refund pursuant to the refund procedure that is established. And that allows the Frontier to refund that fee to the passenger and not pay it to TSA. So
How's that consistent with E3? It says a fee collected shall be remitted on the last day of each calendar month by the carrier collecting the fee.
Right.
There's no exception there.
Right. There is no statutory exception. And I think that shows why Frontier's position is wrong. There is no,
But
except
what you're saying
for
is that
right.
that position isn't what I'm getting at. I probably didn't phrase it well. E3 seems to not allow what you just described as the procedure used. If a passenger pays the fee, cancels the trip, and then the time for remittance arises, you're saying that Frontier doesn't have to pay that fee to TSA. But E3 seems to say it does require it to pay.
I entirely agree with Your Honor that E1 and E3 contemplate a one-way flow of funds to TSA as soon as a fee is collected. But there is a single statutory exception to that one-way flow, which is subsection G. Again, as I was saying, subsection G says that TSA may refund any fee paid by mistake or any amount paid in excess of that required. So as soon as the fee is paid, TSA's authority to refund that fee is triggered under subsection G.
But there's no refund in the process that has been described, as I understand it.
Right.
There's no refund because there's no payment made to TSA if the passenger cancels the trip before the remittance is required. So that's not a refund process. Frontier never pays the money, so there's never a refund by TSA.
TSA, I think that's clarified by the regulations that TSA has enacted pursuant to the statute. And so
Pursuant to or contrary to?
pursuant to, because subsection G expressly authorizes TSA to create a refund procedure and to enact regulations to implement the fee. And what those regulations specify is that that as soon as a fee is collected, that fee is held in trust for TSA. So it's TSA's money as soon as it's been collected, and that airlines have no equitable or legal interest in those fees. So that money belongs to TSA upon collection, and then TSA can authorize the refund of that fee pursuant to subsection G, entirely consistent with the statute. But even if Your Honor,
I don't see why that's a refund if the money is never paid to TSA.
I mean, if Your Honor disagrees, I mean, then it certainly could be, there could be a scheme in which, you know, airlines always have to pay the fee, that they don't have the option to sort of return this fee in advance, and they'll always pay the fee and then refund it later and be reimbursed by TSA. I mean, the functional result of that scheme would be entirely the same. No matter what happens, it's always the case that if the passenger doesn't travel, the airline, the Frontier, should issue a refund to the passenger, and then at some point, you know, there's a question about, you know, does it have to also pay that fee in the next monthly payment, and then when can it offset that fee? And those are issues that we can argue
This seems like
about.
an accounting exercise, and you know, I think Judge Hartz makes a good point, but what we're seeking, the economic reality is that TSA should only get fees for travelers, right? And what's offended TSA here is that Frontier and Southwest and maybe other airlines are getting a bit of a windfall for canceled trips.
Right.
I mean, is that what's driving this
Yes, I mean,
agency
because
action?
it's clear that under the statutory and regulatory scheme, the only two places that the fee can end up are with TSA or with the passenger. Airlines serve only as a collection agent and conduit of funds, both in collecting the fee and in refunding it. So what's happening here is that airlines are sort of taking advantage of their role in that process to keep that fee for themselves, and that's entirely inconsistent with the scheme.
What happens with other airlines like United or American that don't have enforcement actions?
I don't know specifically about any individual airline, but what I do understand from TSA is that there are many airlines that do in fact comply with all of their obligations under the refund scheme, and against which TSA has not sought recoveries of
Well,
the
is there anything in the record or in the public domain that we could look and see what TSA thinks the optimal procedure is?
Well, in terms of what the optimal procedure is, that's laid out in the 2002 and the 2020 guidance. And for an indication of what the airlines do, we obviously don't have extensive evidence in the record about other airlines' practices, but TSA does expressly note in a footnote that we cite in our brief that other airlines do comply with their obligations in this respect, and that is also what I understand from my discussions with TSA. And ultimately, the point of this scheme, this refund scheme, is to ensure that the passenger who actually pays the fee gets the refund. And that only works if the airline is not allowed to keep the fee, because that gives them an incentive to refund the fee to the passenger and earn their goodwill.
The airlines are refunding the fee, except in particular circumstances that they've contracted with the passenger to keep the fee in certain circumstances, and the passenger wants the credit, and the contract with the customer allows that. Why would TSA care about that private transaction?
Because Congress authorized TSA to establish a procedure for refunding the fee in subsection G of the statute. TSA has in fact created such a procedure, and so it's not a matter for private contract for Frontier to require passengers to agree to some other method of refunding
The statute prohibits private contracting of.
It doesn't prohibit private contracting, but it does authorize.
On the fee it does, like, under your argument.
It does not allow parties to establish their own contractual refund procedure that's different from the one that Congress authorized TSA to establish under subsection 4. And I would just point out the extreme consequences of that position, because under Frontier's theory, for example, every airline could just require in its contract of carriage that that passengers give up their right to their security fee refund in advance. And so no passenger would ever get a security refund. And according to Frontier, that would be entirely consistent with the statute. That cannot be right. That would be a complete end run around the refund scheme. And if the same theory were followed in other contexts.
Why would it be an end run? There would still be instances where there are errors that require a refund, right?
Right, and so as I understand it, what Frontier is saying is that they can require passengers through their contract of carriage to agree up front to give up any security fee refund that they are entitled to from TSA. And so there could very well be no refund to any passenger, because every contract of carriage would just say, well, the airline gets to keep the refund, we don't give it to the passenger. Or there could be other variations on it, obviously. They could place it in a travel credit for 90 days, for 60 days, for 30 days, for 1 day, and then upon expiration collect it, or they can say they're applying it to some other fee. But ultimately, there are many contractual ways that they could set this up, where the ultimate result is that the airline gets to keep the fee and not the passenger. And that is the problem. We know in this case that no refund was ultimately effectuated under subsection G, because the money in this case, the money that was collected for the fee that was expressly labeled as a line item, the 9/11 security fee, ultimately ended up in Frontier's books as revenue and not in the pockets of its passengers. And so given that, there is no reason why TSA should recognize Frontier as having made a valid refund and therefore provide Frontier the refund that it seeks. Frontier,
Don't you think the 90-day, the right to use the money within 90 days has some economic value?
the way I would understand it is that when Frontier provides a travel credit, it doesn't actually give the passenger the money. It holds onto the money in its own accounts, but it gives the passenger some beneficial interest in that money, that in the sense that the passenger can use that fee, that credit amount to purchase future travel. But after 90 days, Frontier wipes out that beneficial interest. It takes the money out of the travel.
But when it creates that beneficial interest, it says you can use this for 90 days, that has some value, does it not?
It might have some value. That doesn't make it a valid refund. So for example, if
It's a partial refund then. Then maybe it's not worth as much as having the $5.15 in cash.
So-
But it's worth something, and that should not be,
So-
that value should not be reimbursed to the airline?
No, because the Frontier ultimately got 100% of the money back. It took away that beneficial interest in it, recognized 100% of the fee amount
I
as,
believe in the time value of money.
I'm not sure that bears on this question. I mean, it would be like if Frontier sent a check to someone as a refund, and then before the person could cash the check, that Frontier sent, told its bank to stop payment on the check. And so therefore, ultimately, the passenger was never,
Frontier sends a check, and after 90 days, it can't be negotiated, or after a year, it can't be negotiated. You've seen those restrictions on checks.
Right.
Would that mean that Frontier
I
loses out?
think the force of that hypothetical is because in most cases, people treat sending a check as basically the equivalent of cash. The expiring travel credits here are not anything like that. They can only be used within 90 days for one very limited purpose. So if that would be a refund, for example, I assume that Frontier would not agree to accept, if they prevail in this case, to accept payment from the government in the form of credits good for admission to national parks for 90 days. I see that my time is up. Maybe I could just...
I had another question. I was just wondering if, let's say Frontier sold the ticket, but there was a stipulation that we're gonna have a surcharge of $5.60 when we sell you this ticket, but that we're not, it's only going to be triggered when you get your ticket scanned at the gate at the airport, which means you've gone through airport security. Could they do something like that?
I think...
Because the effective collection is really at the gate, and there would never be a possibility for a refund.
I think that is potentially inconsistent with the statute, which contemplates that the fee will be collected by the carrier selling the ticket, and also with the regulations which expressly provide that the fee shall be based on the itinerary at the time that the ticket is sold. So I think, at least based on the current regulatory regime, that would not be possible. And if I could just finish my thought, it would be odd if, I assume Frontier would not accept a refund in the form of a credit good for admission to national parks within 1 year, because, that's very difficult to use. And if that's not a refund, then I don't think that the refunds that Frontier offered here are refunds either. Thank you.
Any other? Judge Kelly, any questions? Judge Kelly? Okay.
No, thank you.
Thank you.
Thank you.
I think you have, let's make it 2 minutes since Appellant went over a little bit.
Thank you, Your Honors. I just want to make 3 quick points. First of all, on the point you guys were just discussing about refunds, travel credits are plainly refunds in our view. The parties contracted that they would be valid refunds. That's explicit in the contract of carriage. The 11th Circuit decision in Caver says you look at the party's contract in terms of what's sufficient for a refund. The Department of Transportation regulations say travel credits are refunds, and the IRS treats credits as refunds in exactly this air transportation context. So we win just on our secondary argument that a valid refund has been given. Moving back to the first argument, the statutory authority argument, in there are 2 points I want to make about that. First, just a general point, that any doubts should be resolved against the government. This is a longstanding principle that has applied for as long as our tax code has existed, and I would cite, for example, U.S. v. Merriam, 263 U.S. at 188. And so to the extent there's any doubt about how you read the sections in E or G, the doubt should go in Frontier's favor, not in the government's favor. And
Should we treat the expiring travel shells differently than the other refunds?
you mean the 3 instances where there was a cancel fee that ate up the whole credit?
Yeah.
No, because I think that's a valid refund as well. That's exactly what happened in the United Airlines case, and that's exactly what the contract of carriage says. It says we can offset, and that counts as a refund. It explicitly says you can get your refund in the form of a satisfied cancellation fee. And then I wanted to go back to a point, Judge Hartz, that you were making about this fundamental inconsistency in the government's position. They say sometimes a collected fee doesn't have to be paid, and then they put some conditions on it if you gave it back to the passenger. And then they try to justify that by saying, well, we give it back under this procedure under subsection G. Well, as Mr. Shaw said, subsection G says may. So under their theory, they do, but don't have to give the money back if the passenger doesn't travel and there has been a refund. So there's this hugely troubling situation here where if TSA wanted to change its mind, it could say, we're withdrawing this letter. We get to keep the fee even if the passenger doesn't travel and even if Frontier, you gave the money back to the passenger.
Wrap up very quickly, your time has expired, so if you can finish your thought, but briefly.
I was just going to say, and the same thing applies for the utilized travel credits. Somebody gets a travel credit and then uses it later, TSA would get 2 fees if they wanted. Thank you, Your Honors.
Thank you, counsel. Case is submitted, counsel are excused. I should have announced at the outset, we'll take a break at some point, not sure when. Usually between the 3rd and 4th cases, but it varies. Everybody was here for that?
It's interesting.
It's an interesting case, but I wonder if there's someone from every airline or something.
Somebody from Southwest.
Checking our status on the airline. Okay. We'll now turn to our next case on the docket for this morning, 25-2059, Hollis versus Farm Bureau Property. Mr. Vargas?
Good morning, Your Honors. May it please the court. The district court in this case mistakenly held that the relevant and necessary information needed by Mr. Hollis to be alerted to the fact that he might have a claim was available to him in 2013. It was not.
Well, you admitted that, did you not, counsel?
We did not,
Didn't
Your
your
Honor.
client admit that he had all the information
He-
he needed
He did not,
in
Your Honor.
2013?
He did not, Your Honor.
He knew he had not bought stacking, and he knew what the premium was for the car.
What he did not
He
know,
did
Your-
admit that.
what he did not know, Your Honor, and the operative facts, is he did not know that Farm Bureau was actually charging a per vehicle premium, because the documents that were relied upon at the trial court and the documents that he was provided in 2013, 2017, and 2020 clearly showed that he was being charged a per policy premium. And in fact, you don't have to take my word for it, because when Farm Bureau moved to dismiss our complaint, they filed a 12B6 motion. They did not assert statute of limitations, but you'll find this in the appendix at page 56. They made this statement in distinguishing their case from the Garcia versus Allstate case. They said, unlike the Garcia declarations page, the declarations page in this case does not list separate UIM premiums for separate vehicles. The declarations page here does not even contain the premium column that caused the ambiguity problems in Garcia. The
But
declaration.
I thought your paper said that you could tell from the face of the policy documents that there was this premium discrepancy. Isn't that the way the complaint's structured?
That is actually a mischaracterization of the allegations in the complaint. If you read the complaint, what we said was, we are alleging that it is invalid, but we did not say it had the information needed. In fact, on several occasions, and I can point you where in the record, we said they withheld the information and concealed it. You can find it in the complaint at appendix page 9, 10, 11, 12, and 15.
But wasn't the basis for your allegation is because of the language in the policy?
Well, no, actually, the
Basically.
basis for it was that the language in the policy did not inform you of a fact that was learned in 2022 in a separate piece of litigation. It was
Yeah,
called,
but you didn't allege in your complaint anything about the 2022 deposition or the separate litigation.
well, the problem we had with that, Your Honor, is in that case, Farm Bureau obtained a confidentiality order, and it only allowed us to
But
use.
we're here on a 12b6, aren't we?
We are, Your Honor.
So you can't point to stuff outside of your complaint to support an ambiguity, can you?
But we allege in the complaint that they withheld information. We could not share what that specific information was or where we obtained it at the time, but we allege that specifically in those pages that I just cited to you. And Farm Bureau does eventually admit that, yeah, we allocate separate, we charge separate premiums on a per vehicle basis, but they don't want to share that with their insureds. Judge Hartz.
Let me back up a bit. I looked, and I don't think I ever sat on a stacking case.
I
probably
checked-
looked too.
I checked too, Your Honor.
Yes.
You did not.
I was surprised because I've been here.
You had a
So-
lot of
so-
insurance cases.
So correct me if I'm misstating the rationale behind stacking. As I understand it, when you get, I'll just say uninsured motorist, I won't say uninsured or underinsured, I'll just uninsured motorist policy, they cover the insured no matter what vehicle the insured is in.
Correct.
So it doesn't make any sense to have that same coverage if you have multiple vehicles, to have it on each vehicle. You could get the exact same, if it's not stacked and you had $50,000 of uninsured motorists, if it's not stacked, then all you need is one uninsured motorist provision in one policy to get.
That is absolutely a correct statement of New Mexico law, and it's also why our appellate courts say that if you charge a premium on any of the subsequent vehicles, whether it's 2, 3, or 4,
But the rationale is that you're paying for something, if it's not stacked, you're paying for something that has no value. It's illusory.
no, you're actually paying for the stated coverage, which on one vehicle in your
I'm
example
talking
was.
about in general. The reason it's stacked is if it's not stacked, then if you had 4 vehicles, the premium you're paying for uninsured motorists on 3 of those vehicles doesn't give you any additional coverage, so it's illusory.
It's 0.
Okay.
So,
So your issue here, the gist of your complaint would have to be that in some way, the insured in this case could have gotten the exact same coverage for less money.
correct.
And I don't see how you've shown that. This relates to whether the information that came out of this deposition was material or not, whether Farm Bureau withheld material information. From all I can tell from the complaint at least, is the Farm Bureau representative said, you know, these are some figures we use to calculate the premium. Apparently some of that's for uninsured property damage, which doesn't stack because it's only damage to the car that's insured. And then, I mean, I can't tell whether what they did is for each vehicle, they computed what the uninsured property damage would be and then split the rest of the bodily injury to split it evenly among the cars. You can't tell that. Don't you have to show that to prevail, don't you have to show that there's part of this premium that's being paid that was unnecessary. They could have gotten the same coverage for less.
Correct.
And therefore, to overcome the statute of limitations, you have to show that there wasn't disclosure of that fact in some way when the policy was acquired.
Yeah,
Okay, I hope I'm intelligent.
sure. No, and as you know, Judge Hart's from your review of New Mexico law, it doesn't matter how much a premium is, but our courts have found that if there is payment of any uninsured motorist bodily injury premium on an additional vehicle, then you stack, even if it's a reduced premium, because it would be, quote, repugnant to not allow stacking when there's charging of a premium. And in this case, the documents that Mr. Hollis was provided, the documents that the district court relied upon, said it's not stacking and we're only charging one premium for the whole policy.
Right.
But then what we've
But
learned
it's-
is
but it's a substantially lower premium
right.
than if you stacked.
That's what they offer.
That's what they describe.
But
So, don't you have to, I don't really care how they computed what the unstacked premium would be, as long as you couldn't get the same coverage for less money by just insuring one of your vehicles or something like that. And that's what I don't see present here.
Sure. And, well, I disagree, Your Honor, because under New Mexico law, once it is learned that they actually did charge a premium on that vehicle, New Mexico law would reform the policy to make it a stacked policy.
Well, that's not obvious to me, because that's not required by what I understand to be the principle behind requiring stacking. The principle behind stacking is you're charging a premium for something that gives you no value. And how the insurance, I don't know what the person who testified is called, but he's the representative of Farm Bureau. What he wrote down is something that's for internal purposes. And if it is for internal purposes, does it show that he should not have included anything for the fourth and fifth vehicles or something like that? That's what's missing.
And if we're given the opportunity to get into the merits of the case, that is what it will show. But we were not given the opportunity because they said, well, you had all the information you needed had you just exercised reasonable diligence. And reasonable diligence, by the way, as defined by the district court, was extreme diligence, because they said you should have taken your policy to a lawyer immediately. But even had Mr. Hollis done that, had he brought it to me, who's been practicing insurance law for 27 years, I would not have gotten that they are charging a separate premium from those documents. It's only within Farm Bureau.
But here's our problem. There's something that you learned at this deposition. We don't know exactly what it was. That's a problem. But more important, at least equally important, is I can't tell if it's material. And if it wasn't material, then there was no fraudulent concealment, and the statute of limitations isn't extended.
I can give you an example to explain how it's material.
Okay.
At least with the information we have, we know they are charging an amount per vehicle. So if Mr. Hollis had 4 vehicles, let's say, for example, the premium only for UIM coverage is $1,000. If he deletes a vehicle, that goes down to $750. If he deletes another vehicle, it goes down to $500. So it's not illusory in that instance, because he's paying a premium for each vehicle he has on the policy. They're just calling it a single premium, but when they do their underwriting, they're changing it up and charging more money, but they're not giving the coverage that they're charging for.
What if, and I don't know, what if the representative had explained that the way we do it for each vehicle is we prorate among the 6 vehicles, I think it was, or 5, the uninsured bodily injury, and we add to that what each vehicle would be charged for the uninsured property damage. How do we know that that's not what he
That
said?
was not the testimony, but also,
But see, we don't know that.
also, and again, that's information that they conceal, that they don't, there's nothing in the documents.
But
that
if what they conceal is of no importance legally, then,
except that they're selling coverage and not providing it.
well, that's
So
what,
it is of legal importance. And unfortunately, we're getting into the merits of the case when really what we should be
No, no,
focusing on is,
I was concerned about that because
Yeah.
I am talking about merits issues, but how do I know that a fact is material if I don't know your theory of recovery.
Sure. Yeah, absolutely. And our
so-
theory
so
is.
that's what I'm
Yeah,
asking.
our theory is,
Okay,
it's
well,
clear
we
from.
probably exhausted
Yeah,
this point.
but it's clear that that information was never disclosed to anybody. But it's a practice that is occurring, it's happening. They're charging a premium for coverage, but they're telling you you can't stack. And I understand the confusion about, well, they charge a higher premium for stacking. They charge an excessively higher premium for stacking because they want to discourage people from buying stacking because it exacerbates their
You know,
liability.
I did have one confusion on that. It seemed like your client, when he was exploring the coverage to purchase, the insurance agent would say, non-stacking, $200. But if you want stacking, $250. Those are the premium differences. Okay, so he says, okay, I want stacking. Won't he get an invoice for $250 and it'd be clear? And-
Yes.
And it would be clear that he bought that coverage?
Yes.
And if he got a bill for $200, he would know that they underbilled him, or, can you clarify my
Sure,
confusion?
and I guess the issue is not the amount necessarily, but the fact that they're actually charging it on a per vehicle basis. And New Mexico law has always been very clear that charging on a per vehicle basis results in stacking, no matter what.
Wouldn't you know that from the face of the policy?
You really wouldn't. You'd have to, again, the face of the policy simply tells you, you don't have stack coverage, it's a per policy premium, it's one premium. And as they admitted at the appendix, page 56, we don't disclose the premium on each individual coverage. We tell them in the deck sheet, on each car, you have coverage. So unlike your hypothetical, Judge Hartz, they don't delete coverage from cars 2, 3, and 4. They actually, on the deck sheet, show that there is coverage, but then they don't disclose that they're charging a premium for that coverage, and therein is the issue.
May I switch to another point?
Of course, you're the chief.
Well, no, if you're through.
I'm through.
questioning,
I'm through.
okay. Now, Mr. Hollis's daughter has pursued litigation involving the identical policy, is that correct?
Correct.
And under that litigation, the court said, we have to stack, and you're entitled to more coverage under uninsured motorists.
Correct.
And that's the same policy as this.
It is.
So one insured can get what you think should have been allowed to everybody. But if Mr. Hollis is never injured, he gets a refund.
Correct.
So if someone's injured, then you get stacking. If they're not injured, they get a refund because they paid for stacking.
Correct.
So, but if the daughter's result is confirmed in the New Mexico courts, then the coverage by this Farm Bureau policy would have been stacking as a matter of law. even though
Correct.
So why should there be a refund? Because the policy gave you more than what it said it did. It gave you what it should have under New Mexico law.
For the 12 years, the 12 policy periods that he paid those premiums, he should absolutely get refunded because no claims were made in those policy
But if he had made a
periods.
claim, he would have gotten stacked coverage.
He would have gotten-
So it's not in the policy, but it's in New Mexico law.
He would have gotten litigation is what he would have gotten. Whether he would have gotten stacking, I think would depend on who was representing him, what court they were in front of, et cetera.
Can't assume everyone gets someone of your quality.
I appreciate that, Judge. Thank you. I see that I'm out of time, but I respectfully request that the court find that this was timely filed and remand for further proceedings.
Thank you. We'll hear from the other side. Mr. Zimmerman?
Good morning, Your Honors, and may it please the court. My name is Kevin Zimmerman on behalf of Farm Bureau Property and Casualty Insurance Company. Your Honors, the factual allegations in plaintiff's complaint make clear that his claims stem from the face of policy documents he first received from an insurer in 2013. According to the plaintiff, those documents were unlawful and ambiguous in some way and therefore entitled him to stack coverage. The key issue for the statute of limitations on this appeal is that the plaintiff does not allege any changes in his coverage, any changes in his policy documents, or any material facts that changed between 2013, when he first received those policy documents, and 2024, when he filed this lawsuit. The district court therefore correctly concluded that the statute of limitations bars plaintiff's claims. Now, plaintiffs rely...
One thing that troubles me about this case is you don't have to plead that you're not barred by the statute of limitations in your complaint. To resolve that on 12b-6 based on the complaint strikes me as very unusual. It may have been waived by the way the parties proceeded in this case. They said, plaintiff said, we've adequately alleged it already, so that should be assumed as true for purposes of statute of limitations. But some of this is outside the complaint, and I would think ordinarily it would be something the district court should consider in resolving the statute of limitations issue.
So I think
What happened here?
I think what happened here is the complaint is originally filed attached to the 2020 documents, the sort of more recent documents he received, which were materially identical to the 2013 documents. But the court, the plaintiff pled in the complaint, I've had this coverage, these same documents back to 2013. So Farm Bureau, responding on a 12b-6, couldn't point to the documents that weren't attached to the complaint, but the court in looking at that said, look, the district court said, look, these 2013 documents I'm going to consider as incorporated by reference, and plaintiff doesn't challenge that on appeal. So then with those 2013 documents incorporated by reference, it did become a pleading issue because those documents are now sort of part of the complaint. And those 2013 documents make clear that plaintiff first rejected stack coverage all the way back to 2013, and that all of plaintiff's theories as to why the policy documents should be read to provide stack coverage, those facts were available as far back as 2013.
I think Judge Kelly has a question. Judge Kelly, did you want to ask a question?
Yeah, but I'm not getting a picture anymore, so just go ahead.
Well, no, let's stop the clock and let's.
All of a sudden, my picture, you all went out to lunch.
Can you see Mr. Zimmerman at least?
Okay, we got it back. It just came back.
Okay, you have a question? Did you? Okay.
Well, I have a lot of questions. And there seems to be a conflict between what the appellant says and what the appellee says. And I was under the impression that the only argument made to the district court was for equitable tolling, and that the plaintiff admitted that they had all the facts necessary to pursue, but for equitable tolling. Now, am I misreading everything?
No, I think that's correct, Your Honor. The only argument, the only sort of tolling argument presented to the district court, sorry, I think I'm looking up there, is the doctrine of equitable tolling. Plaintiff did not raise the continuing wrong doctrine except sort of saying those words without argument, and plaintiff did not raise equitable estoppel. And as the district court correctly recognized, plaintiff's claims do accrue from the 2013 policy documents.
Well, what if, I thought they're claiming, maybe you're saying they didn't make this argument, but I thought they made the argument that the time to sue was told because they had not been given, because Farm Bureau had fraudulently concealed important information that would enable them to pursue this claim.
That's the argument, but that's not supported by the actual contentions in the complaint. And that's what matters here. The contentions in the complaint, and I'm glad opposing counsel mentioned Garcia v. Allstate, because it really gives light to what the claims in the complaint were. The claims in the complaint were based on how you listed things on the declarations page, and based on the things you said in the rejection form, these documents are ambiguous and therefore provide stacked coverage. And the Garcia v. Allstate case that he mentioned from the New Mexico Court of Appeals, which has actually been subsequently reversed, but the appellate case, which was the operative case at the time, it was about exactly that. The court looked at the face of policy documents and said, look, based on how things are sort of laid out and written out in these documents, I'm going to find that this is ambiguous as to whether or not you're charging multiple premiums, and therefore I'm going to provide stacked coverage. And that, if you look at the motion to dismiss, the merits motion to dismiss briefing here, the parties briefed the applicability of Garcia v. Allstate heavily, because what plaintiff's complaint in the district court was based on the face of the policy documents. It was based on the fact that if you look at the declarations page, plaintiff said, hey, look, you're listing uninsured motorist vehicle premium and underinsured motorist vehicle premium separately above this sort of separate premium, so it's ambiguous as to whether or not you're charging multiple premiums. And the importance of this for the statute of limitations is that all of these claims arise from the face of the policy documents. So as soon as plaintiff received those documents in 2013, he had all of the facts necessary to pursue his causes of action.
Okay, so if I'm understanding you correctly then, the claim was that there was ambiguity in the documents, and because of that ambiguity, under the case you're citing, because of that ambiguity, the insured is entitled to stacking.
That is plaintiff's argument, yes.
And what plaintiff discovered in a deposition of someone from Farm Bureau, and that's for various reasons apparently that was not provided in the appellate record. What the Farm Bureau representative did was perhaps resolve that ambiguity in a way that favors the plaintiff. You probably disagree with that, but that's his argument. And you're saying that the complaint doesn't allege that the situation described by the Farm Bureau representative, it was based simply on the fact that the policy was ambiguous.
So a few points in response to sort of this deposition testimony. So first, your honors are absolutely correct. This deposition testimony is nowhere in the record. And plaintiff's complaint doesn't cite this Nestor case.
You knew what it was because it was your representative who was deposed.
I personally don't know what it was. But for purposes of a 12b6 motion, there's no reference to Nestor. There's no reference to this case's case. There's no reference to any deposition testimony in the complaint. This is just sort of a post hoc argument that plaintiff has created to try to avoid the statute of limitations here. And I think nothing makes this clearer than the fact that one of the two depositions where plaintiff allegedly uncovered this material occurred after the complaint in this case was filed. The 2024 deposition occurred on August 2nd, 2024, plaintiff says, but plaintiff's complaint was filed on July 12th, 2024.
But one deposition was before it was filed.
So the only thing we have in the record as to sort of what was discussed in that 2020 deposition is plaintiff's description of it. And this is at page 180 of the appendix. And I just want to read it for you and apologize for just reading from the appendix. But this is page 180 of the appendix, plaintiff's statute of limitations brief to the district court. Here's what plaintiff says. While Farm Bureau represents and maintains that it charges a single UM/UIM premium at the policy level, the details uncovered in this deposition demonstrate that Farm Bureau actually charges multiple UM/UIM premiums on each vehicle in the multi-vehicle policy. Farm Bureau argues to courts that UM/UIM premium is charged on a policy level, not a per vehicle level, but lists a per vehicle premium on the declarations page that includes the UM/UIM premium as a per vehicle charge. So even as plaintiff tells it in the briefing to the district court, all that was allegedly uncovered is just how things are listed on the declarations page. So that brings us back to the original point.
The complaint didn't attach the declarations page?
The complaint did attach the declarations page. It did.
But it's not listed per vehicle on the...
So the declarations page, what it does is the UM/UIM selection rejection form lists, here's for the separate levels of coverage, here's what the premium would be if you buy stacked coverage, here's what the premium would be if you buy unstacked coverage. Stacked is obviously higher because if you're in an accident, you're entitled to more money for that. What the declarations page does is you can look at the declarations page, and for each of the vehicles there, it lists a separate premium on each of those vehicles, and then it tells you here's your total policy premium.
I didn't see that in the record. What page shows that there's a separate premium for each vehicle?
So I'll pull up the,
I apologize. apologize for missing that. But
No, no problem. I'm looking at document 1.1, page 37, and this is one of the attachments to the complaint. And again, the attachments to the complaint are the 2020 policy forms.
So it's document 1.1.
1-1 at 37.
And what page of the appendix is that?
I don't have that readily handy.
I'm not sure that's in the appendix, is it?
This is attached to plaintiff's complaint, so I would
It
assume.
should be in the
It
appendix.
should be in the appendix. I apologize if it's not,
I kept
between the
looking
two
for
of
a
us.
document that showed each vehicle, but now I know where to find it.
Well, I think I'm looking at least one of them for the Toyota Tacoma. And, you know, it goes through the coverage, then it states stacking rejected, and then it gives annual vehicle premium. And are you saying that there's going to be 4 of those?
There's about 7 or 8, actually.
Okay,
1, 2,
7 or
3,
8. Is
4,
that how
yeah.
many cars were insured?
Correct, Your Honor, correct. So
So
what we
you're saying there's going, and the premium there was $376. There's going to be 7 or 8 of those that show that premium.
That's correct, Your Honor. And you can find the 2020 version of the deck page, as I mentioned, at Doc 1.1 attached to the complaint. The 2013 version of the deck pages, those were attached to our statute of limitations briefing after the district court said, you know, essentially you can attach these things.
Why is that relevant to the fraudulent concealment?
So what's relevant here is the basis of plaintiff's claims are two, you know, sort of disclosure things in these documents. One, plaintiff says, oh, look, you're charging separate premiums for each of these vehicles. Well, to the extent that was sort of discernible from the face of the complaint, or from the face of the documents, which is what is alleged in the complaint, plaintiff had all of the facts necessary to pursue that.
Okay, well, I think here's where I got confused. I thought they were alleging for the uninsured motorist protection. It was separately charged for each vehicle. What is there is the total for each vehicle, but not by coverage.
So
So wouldn't that make a difference if you knew that the uninsured motorist protection was charged independently in each vehicle?
So that is what they allege in the complaint. In their briefing before the appellate court, they sort of argue about separate premiums per vehicle, so it's a little bit confused. But I agree, Your Honor. Paragraphs 21 through 23 of their complaint, this is where they really highlight sort of the basis of this multiple vehicle premium theory. And what they say there is, hey, look, if you look at these policy documents, it lists one premium for the vehicle, but above that are separate lines for auto uninsured motor vehicle and auto underinsured motor vehicle. And when the parties briefed this on the merits to the district court, the briefing was about essentially, hey, under Garcia, does this make this ambiguous or not? And so the critical issue for the statute of limitations is this all just comes from the face of the policy documents. New Mexico law is clear that what matters for the statute of limitations is the availability of the facts underlying the cause of action, not the legal implications.
You seem to be saying their theory of recovery has changed. The theory in the complaint was ambiguity, which should be resolved against Farm Bureau, so they get stacked coverage. Now they're saying, or at some point they were saying, well, we learned something in this deposition of the Farm Bureau representative, and that shows that the uninsured motorist protection for each vehicle was calculated independently. That resolves the ambiguity in our favor, so we should win. But that was not what was alleged in the complaint as their cause of action. Is that what you're saying?
That was not what was alleged in the complaint as the cause of action. And you know, part of what may have caused some of the transition here, there have been 2 New Mexico Supreme Court opinions that have sort of resolved some of the issues as originally alleged in the complaint. The reversal of the Garcia v. Allstate case and Kylene v. Dido. It's 2025 New Mexico Supreme Court 038. This resolved another one of the theories in plaintiff's complaint, which was about offering coverage on a per vehicle basis. But what matters here is if you actually look at the allegations in the complaint. If you look at paragraphs 21 through 23, which talk about the multiple premiums, paragraphs 16 and 17, which talk about the statement in the deck pages, or the statement on the rejection form that stacking has been explained to insureds. Paragraph 40 talks about the complaint does not provide a menu of coverage options. all of the allegations in the complaint, all of the actual claims in the complaint are about the face of the policy documents. And that's what matters for the purpose of the statute of limitations.
I know your time's up, but could you just quickly respond to why our 10th Circuit Aldrich case, which, which states that it's discouraged to review statute of limitations, fraudulent concealment at the motion to dismiss stage?
So the Aldrich case did also expressly said that the statute of limitations can be resolved on a 12b6 motion. That case involved allegations of affirmative conduct to conceal the fraud, which were sufficient to invoke the doctrine of equitable estoppel. And the court statement there is that, sort of based on that record, it couldn't be resolved as a matter of law. But the court also expressly stated in the Aldrich case that, if the situation presented itself, like the situation does here, the statute of limitations can be resolved on a 12b6 motion.
Thank you, counsel.
Thank you, Your Honors. I appreciate your time.
Mr. Vargas, your time is up, but I want to make sure we get this resolved. So I'd like to give you a chance to respond to what I think I figured out from the argument. Excuse me, Judge Kelly. And that is, my understanding now is that your original complaint said you're entitled to stacking because the policy was ambiguous.
That was one of the bases.
Okay, and that was supported by a case that was later revised, at least by the Supreme Court. But then, in arguing fraudulent concealment and therefore equitable tolling, you're relying on additional information at this deposition that resolved the ambiguity in your favor. But my understanding is you hadn't pleaded that there was a resolved ambiguity.
We didn't plead specifically fraudulent concealment because, as you pointed out, at the pleading stage, nobody pleads statute of limitations in their complaint. But tellingly, the Farm Bureau just told you, hey, everything you need to know is up to paragraph 23 in the complaint. But if you review paragraph 23, 24, 27, 29, 30, 31, 33, 39, and 58, you will see that we are alleging that they are concealing information from their insureds, that they have a practice of doing so, and that their insureds cannot make a knowing and intelligent decision to reject the coverage based on that concealment.
Thank you.
Thank you, Your Honor.
Okay, thank you, gentlemen. Cases submitted, counselor excused. You all right to do another one? Mm-hmm. Kelly doesn't seem to be bothered. Next case up is 25-4000, Scottsdale Capital Advisors versus the SEC. Ms. Fritz, you may proceed.
Thank you, Your Honor. And good morning. Miranda Fritz for Scottsdale Capital. The issue before the court here is the district court's dismissal of Scottsdale's APA complaint, seemingly without regard for critical things like the presumption of reviewability under the APA or the specific elements required for an APA claim. And I would argue, based on a false premise. And that's what I want to address today. In the APA case, in the underlying case, Scottsdale was unquestionably challenging the following. The SEC, as it sort of meandered through the Rule 17A8 development, failed to engage in any rulemaking and was acting outside of its jurisdiction because Congress gave jurisdiction over SAR requirements to the Treasury, which in turn gave those to FinCEN, and FinCEN at all times.
You make those arguments on the merits thoroughly.
Right.
Thoroughly in your briefing.
Thank you.
But the question is, or at least one of the questions is, you have to be challenging a final agency action. And the only thing you identified as final agency action in the district court, you repeatedly said it, was the filing by the SEC of the complaint in federal district court in New York.
That is correct.
Okay, so how is that a final agency action?
I just first want to distinguish. What we were challenging was not the Alpine case. What we identified as agency action was the Alpine case, and those doggone things got conflated, I would argue.
No, there was nothing conflated or unclear. You said that the final agency action being challenged was the action of the SEC in filing the complaint in federal court in New York.
Right.
Okay, and
Here's why.
how is that a final agency action?
Okay, here's why that happened. Again, Rule 17A8 in 1981 dealt only with CTR requirements.
No, we're not talking about merits of the decision. We're talking about whether there is final agency action. That doesn't require us to resolve the merits, which you discussed at some length.
Not at all. But we have to look for when was there final agency action as to which the SEC asserted that it had jurisdiction over enforcement of SARS. When did that occur? Because that's what we're challenging. When did the...
No, you're challenging the decision to file, and that is not a final agency action.
That's what I'm struggling with here is that is exactly the false premise that I'm trying to get past. What we were...
Sure, you're trying to get past it, but I don't think you can.
No, we were not challenging the Alpine case. What we had...
No, but you're challenging the filing of you're saying the SEC's action, that's final agency action, was filing that
Right.
case. And filing a case in federal court is not a final agency action.
Okay.
Even filing a case within the agency itself, the Supreme Court has said is just not the sort of thing we call a final agency action. And that is true in spades when it's a filing in federal court, because then you're asking us to set aside the decision of another court not even in this circuit.
Again, all of that flows from the argument that we were filing the Alpine filing. We were not. Here's what we were clearly identifying as agency action. The history of this regulation led up to a series of no rulemaking, ambiguity, all of that, until we got to the filing by the SEC of the Alpine case. And here's why we called it final agency action, because they did. So let me just talk to you for a minute about what's in the briefing. When they filed the Alpine case,
SEC.
yeah, when they filed it, having never before asserted jurisdiction over SAR enforcement, here's what they said to the district court. This case is a matter of first impression that impacts the compliance of both Alpine and all broker-dealers in the financial industry with the requirements of the BSA. The commission seeks injunctive relief to promote the law enforcement policies of the BSA, FinCEN, and Rule 17A8. A judgment from this district court will provide the most direct precedent and clear guidance to the largest segment of broker-dealers within the commission.
Well, isn't that an announcement then to Alpine to, challenge the 17A8 proceeding for the reasons that you're arguing? It seems like that's a claim for Alpine, but not for Scottsdale.
The reason why I emphasize this is
Or let me finish, or conversely, Scottsdale should have challenged the rule during the rulemaking process and not collaterally in the declaratory judgment action that they brought here.
again, we are challenging the rulemaking process, and the only question is, one of the elements is, we have to identify final agency action. So we had to point to something. This was truly when the gauntlet was thrown by the SEC to the industry.
And all the industry was required to do as a result was fight that in court. You're inconvenienced to that extent, but the Supreme Court has said that's not what we think of as final agency action.
Okay.
Action that just makes you respond and argue the point, and then you go to, and so it's the case proceeds.
Okay.
In the Southern District, I believe it was, Aspen loses, and now you want us to set aside essentially the decision of the court in another circuit.
No, I really don't. That decision was,
Do, but you're not, yeah. You'd like us to come up with the opposite result.
what I'm asking is for some court, this court, to take a look at how the SEC utterly and completely failed to comply with the APA. That's what we're asking for.
Yeah,
In order,
but we have to have jurisdiction before. It's a very
That's right.
interesting issue. Love to address it.
Okay.
But we can't address it if we don't have jurisdiction. We don't have jurisdiction until you show that what you claim was final agency action satisfies the requirements of final agency action.
okay, let me just say, throughout this case, I have wanted someone to ask the SEC when they think final agency action occurred. There's no dispute here that final agency action occurred, and it did occur as they filed the Alpine case. And that was their megaphone expressly.
And the action you're troubled with is the decision in that Alpine case,
No.
which is the law that you need to comply with.
Your Honor, I respectfully disagree. The action that we filed preceded the outcome of the Alpine case. We didn't care what the outcome was. And the reason is when they threw down the gauntlet and said, we want to communicate to the industry, we are asserting jurisdiction and we are moving forward. That was the moment when we had an issue, a position that we had to deal with. Eerily similar to this sequence of events is the decision in San Francisco Herring, Ninth Circuit case. And if you go through that case, you are going to see the same sequence of events in that case that happened here. What happened in that case is there were little rumblings that jurisdiction was going to be asserted over certain waters. Notices went out, things like that. But there was also a discussion, just as there was with respect to the BSA. There was pushback from the industry saying, you don't have jurisdiction, FinCEN does. So very similar facts. And then what happened in the San Francisco Herring case is they went out into the water and gave in-water enforcement orders to actual fishermen, saying, we are now enforcing this, and you are subject to criminal penalties. They used a literal megaphone. This is exactly the same thing. We had the same sequence of events. There were rumblings, and then in the Alpine case, the SEC announced its position. I didn't care what the outcome was. We filed before the outcome because what we were dealing with was their announcement that they had jurisdiction and they were going forward. That satisfies the two prongs. It was clearly the consummation of their deliberations on the one hand, and it had legal consequences for the industry. That's what they meant it to do, the filing, not the outcome. That's what they meant to do, and that's what they did.
And what was the consequences to the industry?
The industry at that point understood that the SEC under this, and I don't want to go into the merits, under a different and much more onerous regime, was going to be taking jurisdiction over enforcement.
If it won the case,
No,
the decision, you wouldn't have to do anything until courts ruled in that case.
I really disagree. We knew the outcome didn't matter. Even if Judge Cote had ruled against them, they were going to file these enforcement actions. They were going forward.
If they filed an enforcement action against you, then you'd have a final agency action to challenge.
And obviously, I believe that this does, under the law, Athlone on the one hand, and the San Francisco case on the other hand, satisfy final agency action. Because,
You still have to show an injury, though.
yes,
And you're saying that the injury is from the filing of the enforcement action against Alpine?
the injury comes from their megaphone, their trumpeting to the industry that they are going forward with BSA enforcement. That is when it changed, just as it did in the Herring case.
How does that injure you, your client?
It's very concrete injury. At that point, and it's alleged in the complaint, Scottsdale had to revise significantly its compliance program in order to deal with the SEC's assertion of jurisdiction and imposition of unbelievably onerous penalties that don't exist within the BSA. And so in the complaint, we feel that we have alleged that that announcement, that gauntlet that got thrown,
If Alpine had won that case,
wouldn't have mattered.
wouldn't have mattered.
It would not have mattered. The SEC announced its position. It was going to go forward. If it happened to have lost the Alpine case in New York, it would have continued. That was one district court judge. It would not have suddenly said, oops, I guess we were wrong. This was the gauntlet, and boy, was it thrown.
So, but then, if it had an adverse ruling in the federal court in New York, then it could proceed in the next case. And once it issued an order, there'd be a final agency order, or given that they decide to proceed in court, they don't issue any orders. You end up with a decision by a federal district court in some other circuit, and then a circuit decision, and then you either win or you lose. But the agency hasn't issued a final agency action.
In these circumstances, this announcement, in the wake of the rumblings that had preceded it, was the consummation of the agency's deliberations, and it was expressly so. You are rarely going to find an agency saying, through this filing, we are communicating to the industry, to all broker-dealers in the financial industry with respect to the requirements of the BSA. And we're doing it to provide clear guidance to the largest segment of broker-dealers within the commission's purview, because
Your time has expired, so wrap it up. You can wrap up your sentence, but you still have 24 seconds. The clock is showing how much you've exceeded your time.
Thank you. I would ask that Your Honor really take a look at Athlone and the Herring case in terms of whether that action, the position announced by the SEC via the Alpine filing, satisfied the two elements of final agency action.
Thank you. Would someone please close the back door, please? Ms.
Good morning, Your
McKenzie?
Honors. Good morning, Your Honors. May it please the Court, Rachel McKenzie for the SEC. No authority supports Scottsdale's position that it can file an EPA lawsuit over a complaint or the positions the commission took in an enforcement action that it litigated against another party in another federal court.
I'm sorry, say that again? That was too fast for me.
Apologies, Your Honor. I said no authority supports Scottsdale's position that it can file an APA lawsuit over the complaint and the positions the commission took in a litigated enforcement action against another party in another federal court. I think the district court's analysis of Scottsdale's failure to identify final agency action is compelling and correct. The SEC's decision to file the Alpine action and the arguments it made to the court in that action did not determine any rights or obligations. The court's decision in that case determined rights and obligations. I'm happy to discuss the Herring case because I think that's actually quite helpful
Yeah,
here.
if you respond to that and also to the Appellant.
Absolutely, Your Honor. So in San Francisco Herring Association, what was at issue was the Park Service issued what the court referred to as no fishing orders. And it said that those orders were a display of legal force where immediate compliance was expected. And the court said that those orders were markedly different from a complaint with which immediate compliance is not expected. The parties who receive complaints are under no order requiring them to act. Exactly so here, the commission filed a complaint, it made allegations, and the court decided what it decided, but it was not the commission's complaint that determined any rights and obligations. As for Appellant, Your Honor, I think the district court actually did a pretty good job of explaining why that case does not control here. Number one, it seems to, as Judge Williams later said in the Tycor title decision, at odds with the Supreme Court's decision in FTC versus Standard Oil, because the Appellant decision does not address whether or not simply having to go through an administrative proceeding is a denial of a right or an imposition of a burden. The court in Sokol, of course, said that it was not. I would also add that Appellant arose in the context of an administrative proceeding. That case arose, it was sort of in the pre-Axon world where there were always these questions about when you're in administrative proceedings, at what point can a party pop out of the administrative proceedings and get review by a court? Of course, that is not at issue here because the commission itself went to court and asked for judicial review of these issues.
So you actually think Appellant was wrongly decided, but even if it was, you would distinguish it as involving an administrative action?
I would, Your Honor.
But the theory behind the court in Appellant was that the court was declaring its jurisdiction to do something.
It was the...
And that's kind of what's going on here.
I'd say it was slightly different. What was at issue in Appellant was the agency was asserting its jurisdiction to both run the proceedings and at the end of it potentially impose penalties. Of course, in a enforcement action in district court, it is not the agency that is asserting jurisdiction to govern proceedings or to issue a penalty. Those are all decisions for the court to make. And of course, those court decisions have legal consequences, but they are not final agency action. When an agency does engage in final agency action, of course, an aggrieved party can seek review of that action within a certain time frame defined by Congress. The Supreme Court and this court have said that specific and discrete final actions are subject to APA review. And there were moments here when broker-dealers could have sought that sort of review, when the commission promulgated Rule 17a8, when the Treasury Department promulgated the SARS regulations, when the commission amended Rule 17a8 in 2011, but neither Scottsdale nor any other broker-dealer sought that review. Rule 17a8 became final and effective. The commission filed a complaint to enforce the rule against Alpine, and properly raised arguments were addressed in that action. Scottsdale's argument seems to boil down to this idea that, if we think that the commission should have engaged in additional rulemaking before it filed an enforcement action, you essentially just dispense with the requirement under the APA that a plaintiff identify final agency action. But that's just not how it works. And I think potentially helpful decision for Your Honors to take a look at is the Third Circuit's recent decision in Coinbase versus SEC, which is at 126 F. 4th 175, and particularly at page 191. That's a decision from this year. And it arose in a slightly different context, but there was the same sort of flavor of the commission can't choose to litigate case by case, it has to engage in rulemaking, and the Third Circuit said that's not true. And one of its reasons was, assuming for argument's sake that the SEC has tried to make regulatory changes in some or all of its enforcement actions, the appropriate way for a party to raise a fair notice argument would be as a defense in those enforcement actions. That's the way it works. We adopt a rule. At that point, there's a limited period of time at which people can raise challenges. When that time passes and the commission proceeds to seek judicial review over the contours of that rule, any party against whom the commission seeks an enforcement action can raise appropriate defenses, exactly as Alpine did in the Alpine action, exactly as Scottsdale could do if we filed an enforcement action against Scottsdale. Unless your honors have questions, we'd ask that you affirm.
Thank you, counsel.
I would like you to
Sure.
respond to the standing issue, and it does seem like there's going to be the possibility or the likelihood of increased cost to Scottsdale because of this, now new world order that there's 17A is going to be enforced. Why isn't that enough of an injury in this situation, assuming for purposes of discussion, final agency action?
Yeah, I think exactly for the reason that the district court said, which is that to the extent that Scottsdale faces increased compliance costs, that's because the commission won in the Alpine case, and there is now a SDNY decision and a Second Circuit decision that says that Rule 17A applies to broker-dealers and they have to comply. It's not the result of the complaint that the commission filed in that action.
Is there any remedy under the APA for that sort of thing? For what they're saying? Could we require the agency, I guess it would have to be, well, let me put it this way. For there to be any remedy, you need to have some remedy before you have standing. And the remedy here would seem to be our reversing the Second Circuit. Is there any remedy that could be permitted under the APA? Can we issue a declaratory judgment under the APA remedies provision?
I don't think there is a remedy that your honors could, and your honor brings up an excellent point about redressability, because of course the remedy for agency action that is unlawful under the APA, that's section 706, would be to set aside agency action that's unlawful. And of course that highlights the exact problem here, as your honor highlighted earlier. This court cannot set aside a complaint that was filed in a different court, and of course it can't set aside the decisions of that court. So there is an enormous redressability problem here.
Well, could we declare the law? Is one of the remedies permitted declaratory judgment?
It's to declare unlawful and set aside agency action, but again, that just highlights
Can
what
it simply declare it unlawful and not set it aside? We can't set aside the complaint. Can we declare the complaint unlawful?
I would say no, Your Honor. Section 706 says declare unlawful and set aside agency action found to be arbitrary, capricious, all of the.
So if you declare it unlawful, you have to set it aside, as you read the APA.
I think so, Your
Is there
Honor.
any case law on that? Do you know?
I'm off the top of my head, I'm not aware.
If you run into some, we wouldn't mind a 28-J letter.
Absolutely, Your Honor.
Not sure it's going to be dispositive, but I'm sorry, Judge Kelly. At one point, you're going to realize it's not worth listening to me, but I'll try to talk into the mic better. Okay, so no more questions?
I have no questions,
Thank you.
Thank
Thank
you,
you,
Your Honor.
counsel.
if you were wondering.
Okay. No, you had, well, respond to what? The redressability issue?
Just ask a question about remedies. I was wondering
If you have any case law on whether we can order something unlawful, declare something unlawful, but not set it aside, do you have something on that point? Because if you do, you can do it through a 28-J letter.
Okay. No, the remedy we're seeking is a declaration that they failed to comply with the APA.
Well, she's indicated she doesn't think that's allowable in an APA review. That's not redressable. If you have something to say on that, you can do that in 28J.
All right, thank you, Your Honor.
Well, again, thank you, counsel. Case is submitted, counsel excused. We'll take a brief recess at this time.
Or will be a recess petition.
it's a good idea.
Good. Please be seated. Judge Kelly, are you there? Good. We've got a couple more cases. Okay, you don't have to sit down. Mr. Hammonds, we're going to hear Dominguez versus Weiser Security Services, 25-6061.
Yes, Your Honor. Thank you. Thank you, members of the court. My name is Mark Hammonds. I represent Juan Dominguez, who is the appellant in this case. Mr. Dominguez was fired after participating in an internal investigation to discrimination in which he reported his supervisor, Mr. Yates, was engaging in gender-based discrimination, favoritism towards females. The court found against us, claiming that we had not established sufficient knowledge to sustain the third prong of the retaliation case. Now, it was undisputed in this case that both the putative decision maker, Mr. Strickland, and the person we claim to be the instigator of this, Mr. Yates, knew that Mr. Dominguez had participated in a discrimination investigation.
Not a gender discrimination, though, right?
Pardon me? Not gender discrimination. The basis for the, Mr. Yates said, I know, Mr. Dominguez, you've initiated this. I know it's about me favoring women, and I know that, or suspect that you're going to report me for that. Now, I said that before Mr. Dominguez had done any of those things.
I'm sorry. When did Yates say, you're saying Yates said these things?
Yes, Yates said those things. Yates is the supervisor.
And he said it to whom?
He said it to my client, Mr. Dominguez.
But the issue is whether Mr. Strickland knew that, and the record is that he did not know about the gender discrimination allegation.
Yes, that is the
And he's the
testimony.
decision maker for the
Well,
termination, so how do you get around that?
Well, the cat's paw doctrine, Your Honor, which we raised and fully briefed in that case, all of the basis for the termination, everything that Mr. Strickland said was the reason, was information given to him by Mr. Yates. There was no investigation of Mr. Yates' allegations. One of them, the court found the evidence was so lacking that he determined on summary judgment that there had been no instruction for Mr. Dominguez to appear at a June the 13th training exercise, which Mr. Strickland said, at least at one point, was the straw that broke the camel's back, causing him to be terminated. There is no prior record of discipline, infractions, failures of performance, anything on the part of Mr. Dominguez. So the standard for...
Well,
yes?
Counsel, wasn't there a whole series of things that Mr. Dominguez didn't come to meetings, didn't do payroll, didn't do the training, just one thing after another?
Well, that's what was claimed, Your Honor. There were no contemporaneous admissible records to show that those had happened. It was undisputed that no one had talked to Mr. Dominguez or claimed any of those things prior to the date of his termination. His disciplinary and performance record was completely clean up to that point in time. There were records that were excluded by the court properly on a hearsay ground, but even if they were considered, they were created after Mr. Yates became aware that an investigation was going to take place, one that he blamed Mr. Dominguez for, and one where he correctly predicted that Mr. Dominguez would raise an issue of gender discrimination.
So I want to make sure I understand your statement that Yates said certain things to Dominguez about gender discrimination.
Yes.
There was a conversation,
Excuse me.
as I understand it, where Yates told your client that they had to get aligned and had to start working together, because if they weren't going to work together, it was going to be either your client's job or Yates's job.
That's correct.
Is that what you're referring to when you say Yates told Dominguez that he knew Dominguez was complaining about gender discrimination?
No, there's a more direct complaint, which we quoted, and the court discounted. Mr. Yates said, I've got a problem with women. I know I've got a problem with women. I know or think that's the basis for the investigation. It was not. It was a race complaint. He was wrong about that. And he said, I don't know if I'm going to quote this exactly right, but I know that you are the source of this investigation about gender discrimination by me. And he said all of those things with, actually, it appears within a span of a couple of weeks before the investigation was actually commenced. What the court said about that in its order is that most of Dominguez's cited evidence pertains to events that occurred before the plaintiff made his report on June the 10th. Necessarily, this evidence cannot demonstrate that Mr. Yates harbored a discriminatory animus on the basis of plaintiff's yet unmade gender discrimination claim. In other words, he said, if you haven't done it at the time, I'm not going to consider what Mr. Yates said was his motivation and his belief. Now, respectfully, Your Honor, I've not found any case where it has not been accepted that a person's beliefs are evidence of their motive, and motive is evidence of causation. The court did not cite any case that would support such a finding. The defendant didn't cite any case.
But you're saying that Yates, I missed this, I think. You're saying that Yates said, they're investigating gender discrimination.
No.
And
Well, yes, he did.
yes,
That
he thinks, Yates says, I think I'm being investigated, I think it's gender discrimination. And he says to Dominguez, and I think you're the one who's responsible for this.
Yes. Yeah, and that's in the record. There's no contrary evidence in the record because Mr. Yates was not capable of being deposed by either party with regard to that.
And that exchange was presented to the district court. It wasn't just in the record, it was part of the argument.
It was part of the argument, Your Honor, and it's part of the argument that the court addressed. He acknowledged those statements, he acknowledged that evidence, but it said it didn't matter because it happened before Mr. Dominguez actually appeared and gave his evidence. We argued specifically that a person's belief is sufficient on that issue. Now, I will tell you, I haven't found a 10th Circuit case that says belief is the equivalent of knowledge, but the Supreme Court has said essentially that belief is the equivalent of knowledge in the Heffernan case, which we cited to the court. I will say the court found our argument undeveloped, even though we plainly said belief is sufficient to establish the knowledge component. And we cited Heffernan, summarized that it said even a mistaken belief will support a retaliation claim, and cited Wrights versus Hoy Shoe, which said, and we did that for the common sense quotation it had, and that is we know that employers make their decisions as much based on what they believe as on what they know. Now, I don't think that's underdeveloped. I will tell the court I've not found a case of this circuit giving a bright line example of what's sufficient, but, and although it's not precedent, the court's manual for attorneys and briefings suggests that two good cases with appropriate paid citations, an appropriate quotation, an appropriate summary is usually considered a good and sufficient argument. And the court said in the practitioner's guide, a series of string cites was not particularly helpful.
Can you really kind of circle back in a very short and concise way, one or two sentences, say why there's a fact question on the cat's paw theory?
I'm sorry, what?
On the cat's paw theory?
On the cat's, well, the courts acknowledged that two of the prongs were established.
Tell me what very concisely, like if you were telling a jury, the cat's paw theory, A, B, C, D, therefore cat's paw.
Mr. Yates believed that our client was the source of an investigation against him in which our client was going to raise issues that he acknowledged he had a problem with, gender. The only source of the information giving rise to the client's termination was the information that Mr. Yates supplied to Mr. Strickland. There was no intervening investigation, which is not automatically a breach in the chain under Staub. And the only reason for the termination was the information given to Mr. Strickland by Mr. Yates. That is all of the elements required to establish at least a jury question on cat's paw. And the only reason...
Strickland never did any investigation of his own. He never talked to
The only time he talked to the plaintiff was the morning that he fired him. And he didn't ask him to verify or address the results. If he'd done any kind of investigation, there were two people who were supposedly instructed to appear at this June 13th training session. Neither of them, my client was one, but the other one also said, I wasn't notified about that, and he didn't attend, was not disciplined in any manner for his non-attendance. So it would have been easy to conduct an investigation. Mr. Strickland did not do that, despite the fact that there's no record of any performance issue or disciplinary problem prior to the termination on June the 19th, I believe was the date of that. So the reason why the court did not credit the cat's paw doctrine was one only. It said you can't show that Mr. Yates was motivated by animosity based on retaliation because there had been nothing to retaliate against at the time he made the statements saying, essentially, I'm going to retaliate against you. I guess if he appeared and testified for the investigation. I think a jury could fairly infer that he simply predicted what he thought was going on, part of which was correct, and then acted upon that. Now, he may not have known the words that were said during the investigation, but they knew that there is an event that is a protected event, participating in an investigation into discrimination. They knew, both the decision maker and Mr. Yates knew that my client had participated in that, had given evidence in that case. The only thing that they didn't know are the exact words that he said during the investigation. And the 10th Circuit, to my research, has never said that degree of knowledge is required to establish the third prong of causation in a retaliation case. There are some courts that have expressly said that a suspicion is enough to give rise to protection to satisfy that third prong. Our court has neither accepted nor rejected that proposition, but I would suggest that that's a common sense proposition that would have to be followed in light of the Heffernan decisions and the decisions of this court, which have followed since that in the Byrd case and in the Avant case, where you've recognized that a person doesn't have to even make a protected statement if the other person thinks that that's what they're doing. And of course, even preceding that in the Sowers case, the 10th Circuit.
Can you remind me, Yates was not deposed, right?
Pardon me?
Yates was not
Yates
deposed.
was not anywhere in sight when the trial was going on.
And so what's the basis of your statement that Yates could have predicted that Dominguez had told about the gender discrimination to Ms. Sutherland?
Because he said that to Dominguez. He said to Dominguez, I know I've got a complaint with women. I know you've raised that issue before. I know that you're the one initiating this investigation. He's wrong about that, of course. But in his mind, he knew that was the case. And those came from his lips. They were admissible, not challenged as being inadmissible.
Well, Yates was being investigated for racial discrimination, wasn't he?
Yes.
But not gender discrimination.
Not, the genesis of the investigation was not race. Yates thought it was gender. He did not know it was race. He thought my client would report gender discrimination. He was right about that. His prediction was correct. My client did report that. I'll reserve my 10 seconds, I guess.
Thank you, counsel.
Thank you.
Mr. Watley? Did I pronounce your name correctly?
Yes, you did. Thank you, Your Honor. May it please the court, my name is Nathan Watley. I represent the defendant appellee, Weiser Security Services, in this matter. And I do want to go back to some of the questions that the court had and some of the statements that were made by counsel for the appellant. And I've got some concern about what he's trying to say there. He came forward and said that Mr. Yates said to the plaintiff that, I know you initiated this, know you're going to report me for gender discrimination, and that we need to get aligned. He tried to tie all that together into one conversation. And he made that same attempt in the underlying case, and the court called him out for it. The judge found in his initial order granting summary judgment, in footnote 24, which is on page 25 of the order, and the appendix, page 490. Again, here the plaintiff claims that Yates told him, I know you complained to me about Robert and Mike, and we better get aligned. It was going to be my job or his. And the court said, this is a glaring mischaracterization of the record. Plaintiff cobbles together part of his deposition testimony with the question from his counsel posed 35 pages later to make it appear as if Mr. Yates' comments about getting aligned were tied to plaintiff's earlier complaints to Mr. Strickland and another gentleman at Weiser about gender discrimination.
Aside from the timing of these events, did Mr. Dominguez testify that Yates said to him, I think I'm going to be, there's an investigation against me, I think it's going to be based on gender, and I think you started, or words to that effect?
No, Your Honor, that didn't happen at all. That was not his testimony. He testified that there was an earlier situation.
And what was the earlier situation?
It was one investigated by Mr. Bullock and Mr. Strickland that didn't involve Mr. Culberson at all. It wasn't being investigated by the HR team. It came previously, and there had been some complaining about that.
What sort of complaints?
It did involve favoritism allegations toward women, but it was previous in time, and it wasn't tied to the investigation that was going on in June.
How long before the June investigation?
Your Honor, I want to say a matter of a couple of months. It may have been longer than that, but it was definitely.
So why is it so outrageous then to say, well, thank you. I'm going to get a hunchback doing this, but I'll try to talk into the mic. Why is it so outrageous to infer the following? That Yates suspected Dominguez of complaining about Yates for gender discrimination, discriminated against men, favoritism toward women, and saying, I know you're the person who initiated the investigation. And then a couple months later, during the investigation, he is investigated for gender discrimination, and he now thinks that Dominguez has complained about him to the investigator, and therefore why is that not a reasonable syllogism there?
Well, Your Honor, a couple of different things there. He didn't say that he thought that Yates did not say that he thought that plaintiff had initiated the investigation that was happening in June. He said, I know you had complained about me to the other individuals, and that part of what his complaints were was favoritism. It wasn't really couched in terms of a gender discrimination complaint. It wasn't taken to HR in the same way that the one in June was taken with Mr. Culberson's race discrimination.
When it was taken to HR, there was no component of gender discrimination in it?
That's correct. None. It was none. It was purely a race discrimination claim brought by Mr. Culberson. And also, it's important because, again, they're trying to tie two conversations together and make it sound as if on the very eve of going in for his interview,
2 months earlier is not an unreasonably long time to harbor resentment and suspicion of someone. But he said nothing to indicate that he thought that Dominguez had complained about favoritism toward women? Did he not think, did he not? He didn't say something to Dominguez about, I know you think I'm playing favorites?
no, not in the context of the upcoming HR investigation.
At any time?
Not in those words, no, Your Honor. All he said was, allegedly said was, I know you complained about me to Mike Strickland and to Mr. Bullock. Again, it was not in the context of an HR complaint.
And was there any
And there was no,
indication of what the complaint's substance was, whether it was about race or whether it was about gender?
there were a number of things that he was complaining about in terms of management style, giving people breaks and things of that nature. Now,
Did what Yates say indicate what he thought Dominguez had said negatively about him?
no, Your Honor. All he said was you had complained about me to Mike and to Mr. Bullock. And that, again, this was a separate conversation. The later, the conversation about getting aligned, which plaintiff has tried to return to again and again and used to say that there was some connection, didn't have that connection. You have to keep in mind that that conversation occurred before Mr. Yates even knew there was going to be an investigation in June. He hadn't been told that there was a complaint or that HR was coming to investigate. It was allegedly 2 days before he would have ever even learned that any kind of investigation was going on. And so, again, there's just not that connection between a general statement of we need to get aligned and we need to work together or else one of us is going to be gone, and then trying to bootstrap that into somehow he's predicting in advance that there's going to be a complaint in a few days by someone else, that Mr. Dominguez will testify in that, and that he'll raise something completely unrelated to the underlying complaint. There's just no evidence tying all those together, and this suggestion that plaintiff keeps making that it was all part of one conversation or that there was even a conversation where he said you've initiated this is just not accurate. It's not in the record. With regard to the cat's paw theory that there was some discussion about, plaintiff is maintaining now that everything that Mr. Strickland gave as a reason for the termination of Mr. Dominguez was provided by Mr. Yates. Again, that's completely not accurate. In addition to, he had gotten complaints about Mr. Dominguez from Mr. Yates with regard to performance and failing to perform, but also, and much more importantly, he had gotten complaints from Chip Ford, who was the client representative for Halliburton and who was responsible for deciding whether or not Weiser got to stay there and keep.
But Ford was complaining that the training for COVID was inadequate.
That was one of the things, Your Honor.
He wasn't complaining specifically about Mr. Dominguez, was he?
Well, in the sense, yes, and yes. Because Mr. Dominguez was supposed to do the training, and he didn't follow the
But
script.
Ford didn't know that. He just knew
Well,
that the training wasn't adequate.
Correct, but Mr. Strickland knew
Yeah.
who did it.
Well,
And
how did he know?
Because
he knew it from Yates, right?
I think he may have known it independently because it was a big deal. Halliburton was really, really keen on getting this rolled out. They were hyper vigilant at that time about everyone being trained in a very particular way. They wanted it to be carried out according to the
Mr.
script.
Dominguez's excuse was Yates had not told him to show up the next day, that he had interfered with him and asked him to do something else. And Strickland never heard that. Strickland never, I mean, this guy's fired without having an opportunity to present anything to the person firing him. Is that fair to say?
I think he had a chance to discuss with him, what was going on at the time, but the decision had been made, Your Honor. But certainly there were additional points too that Mr. Ford raised having to do with directly having to do with Mr. Dominguez's behavior with regard to reporting his own COVID symptoms, going into the very small guard station while he had COVID symptoms, not wearing.
That came from Yates.
No, sir, that came directly from Chip Ford, to Mr. Strickland, because Chip Ford could see it on video, and he knew.
That Dominguez had not said, had not worn a mask and did not report that he was going to be tested for COVID.
Correct, and that he had gone into the guard station in a very enclosed area where they didn't want multiple people. On top of that, while he had COVID symptoms. So those things were reported directly to Mr. Strickland by Mr. Ford.
It just seems to me a little suspicious that someone who less than a year earlier had been the only one named as Employee of the Year is then fired without being called in to explain himself and see if there was any excuse he had. That strikes me as peculiar conduct.
Well, I think the preponderance of all the things that Mr. Strickland was seeing led him to that conclusion that he needed to make a change.
But he concluded that without hearing if there were any excuses or any other side to the story.
Your Honor, I understand your point. However, that really doesn't go to the issues that are in front of the court on this, because we're talking about the prima facie case, not whether it was pretextual and that they had a good reason to terminate.
Pretext can be considered in determining whether there's a prima facie case.
In very rare cases, though, Your Honor.
But it can be. I mean, it's relevant.
Not usually, no, it's not usually relevant, nor it has to be something that goes to prove that element of the prima facie case. And here it does not. The fact that they may have done something that seems unfair, you know, we may not agree, or we may agree that that's not the best way to handle the termination. We all could agree to that, perhaps.
Making a good case against McDonnell Douglas, thank you.
But that's the case, Your Honor, and I think we have to live with that. And this court has recognized that and has to live with it. You've got to get through that prima facie case first. And only if...
I'll just tell you, I wrote the Wells case way back. And the thing that I spent more time on than anything was, can we consider what was clearly pretextual in determining whether there's a prima facie case? And there was some authority out there, and that was the deciding feature in that case. The fact that there was a pretextual reason for firing got the plaintiff through the prima facie case requirement for
But there, I think, Your Honor, was a little bit, that case didn't involve whether or not someone knew about a report of, or a protected activity or had knowledge of it. So,
wasn't the issue there, yeah.
right, and so there was the opportunity for that issue that would normally be pretext to go through and help establish an element of the prima facie case. That's not the case here, because that has nothing to do with whether or not they had knowledge. And there's nothing to show that either of the individuals, Mr. Yates or Mr. Strickland, knew what was reported or said by Mr. Yates in that meeting. The plaintiff talked about, you know, that Mr. Yates could have predicted maybe what he would say in an investigation, but he would have had to have predicted what the complaint was about, which it wasn't about gender, and then would have to have predicted some other things, but there's no evidence that he did. There's no record evidence to show that he ever made a comment or did anything to show that he believed there had been some sort of complaint against him by Mr. Dominguez in that June 10th interview. And that's what the claim in this case is. The claim is not that Mr. Dominguez was fired because he participated in someone else's complaint as a witness on an internal investigation. The claim that you can see in all the briefs is that he was terminated for reporting alleged sexual harassment and gender discrimination as part of that. And nobody that was part of that decision-making chain knew that at the time.
Can you comment on this knowledge-belief dichotomy that counsel was talking about?
Certainly, Your Honor. If you look at the cases that he cited, a lot of those have to do with mistaken belief as opposed to, or they have to do with the preemptive retaliation situation, and that's not what we have here. He's finally admitted in the briefing on appeal that they don't have a preemptive retaliation claim, and it's not a mistaken belief case. They didn't have a belief one way or the other about what he said inside that meeting, and they didn't have knowledge of it. So to the extent that those cases are being relied upon, they're not applicable. Also, the There's just no evidence, Your Honor, to show that he had that belief, and that he was acting on it to either intercept or to retaliate for that purpose. The record that's in front of the court simply doesn't show what Yates believed. As was noted before, he wasn't deposed in the case, and there's not any record evidence of any kind of alleged statements by Mr. Yates relating to what he thought happened during the investigation. Thank you, Your Honor.
Thank you. Any questions, Judge Kelly?
No, thank you.
Thank you, counsel.
Thank you.
Yeah, you've got 10 seconds, okay.
I'm going to direct the court's attention to page 28 of the opening brief and the quotation from the deposition. Now, did Mr. Yates express to you in the weeks prior to June 10th interviews that he knew that complaints about gender treatment had been made against him? Answer, yes. You indicated you had a conversation where he admitted he had a problem and treated women better than men. Answer, yes. Was that conversation one that occurred within the time period shortly before the interviews? Yes. Okay, in connection with that conversation, did he tell you that he knew he was going to be investigated for that? And the answer was yes.
Thank you.
Thank you.
Well, I'm still going to thank both of you. Case is submitted, counsel are excused, and we'll go to our final argument of the day. Put on my glasses. 25-6073, Universitas Education versus Phoenix Charitable Trust. Mr. Sandberg, appellate counsel.
Good morning.
Mr. Sandberg.
Thank you. May it please the court, counsel. I need to start by apologizing. When I came in, I had to make a choice between potentially fighting with the door and interrupting the prior oral argument or closing it as best I could. So I tried not to disrupt anything. I figured fighting with the door was not a good option. So I'd like to begin here today by talking about the personal jurisdiction issue. And when we look at that,
Well, excuse me, counsel, you're representing Phoenix?
I am today, yes, sir.
Okay, thank you.
When we look at this issue, the court lacked personal jurisdiction over Avon, Wyoming, when it lost Article 3 jurisdiction back in December 2020. And the court looks at this under a de novo review, standard of review, because it's a discussion of personal jurisdiction.
Excuse me, again, counsel, how do we have jurisdiction here? Phoenix was never, he was a non-party.
Let me address that then, Your Honor. And we discussed this in our brief. What we're talking about here today are post-judgment orders. And when we think in terms of post-judgment orders, okay, it begins with the district court's order that any interested parties regarding former SDM Oklahoma could appear in court. And that is what Phoenix did.
Well, but they didn't become a party, though. They never were permitted to intervene, were they?
Former SDM Oklahoma never asked to intervene. So they did not formally become a party, but they did make filings as an interested party in compliance with the district court's order. Now, when we talk about post-judgment orders, there is precedent for parties who are not parties below to be permitted
Before we get to that, it seems a little nebulous to me. Is Phoenix is filing documents on behalf of whom?
Well, Phoenix, this is confusing, I think, in some respects, based upon the orders in the district court.
Fix that.
I'm sorry?
Yeah, fix the confusion for me.
Well, it's confusing for me. I would never assert that the court's confused.
You're their
but
lawyer.
Yeah, but it's confusing for me. And the problem is, it's undisputed. SDM Oklahoma ceased to exist when the merger occurred back in 2017. Additionally,
Merged with another corporation.
it was merged with another limited liability company up in Connecticut. But in addition to
Well,
that,
this is part of the, excuse me, isn't this part of the whole David Carpenter debacle?
well, I don't know that I can agree with that, Your Honor.
What, the debacle or with David Carpenter?
Well, I mean, Daniel Carpenter has been accused of a number of things over the years.
He has, he's gone to jail for a pretty long time, too.
I cannot dispute that, Your Honor. When we talk about former SDM Oklahoma, though, in addition to the merger, there's another very important aspect to this. The Oklahoma, I'm sorry, I'm from Dallas. The Oklahoma Secretary of State's office records affirmatively show that SDM Oklahoma ceased to exist in 2018, and it was canceled in 2021. And so it does create some confusion because what we...
So who are you, Phoenix, filing documents on behalf if SDMs cease to exist?
Well, Phoenix is an interested party here because
How do we know that?
the district court authorized it to file, and it has been filing, and in the filings...
District court said any interested party can file, right?
Yes.
Okay, and what is your interest?
And so the interest that the interest that Phoenix has is it was formerly an owner of what was SDM Oklahoma. And it is an owner in what is now SDM Connecticut, the Connecticut LLC. And so it is filing
Was
these
it
things.
Avon, Connecticut? Is it Avon, Connecticut, or SDS, Connecticut? I'm confused about that.
The name of the entity is SDM Holdings LLC. It is a Connecticut limited liability company. Phoenix.
And what is Phoenix's interest? I mean,
Phoenix's interest.
what is the financial interest of Phoenix in these proceedings, and where can I confirm that in the record?
Okay. It's in the multiple filings that Phoenix makes, and we also include a discussion of it in our brief. And Phoenix was formerly a owner of what was SDM in Oklahoma and is a holder, or a member, excuse me, of the SDM entity in Connecticut. And what is happening in the district court, and certainly no disrespect intended to the district court or to this court's prior opinions, but what is happening in the district court is that these policies, these assets that cannot belong to SDM Oklahoma because it hasn't existed for years, okay, are the subject of a receivership via Avon, Wyoming. Avon, Wyoming has indisputably not existed for even a longer period of time. And so Phoenix is here because it is Phoenix's economic interest or financial interest in these assets as a member of the LLC that actually does exist, which is...
What are the assets that
Phoenix
thinks it has a claim on?
Okay, the assets are a series of insurance policies that were previously owned by SDM Oklahoma when it existed and are now owned by SDM Connecticut.
Let me go about this a slightly different way. Because your interest and I think the jurisdictional issues depend on what relief you're seeking here.
Yeah.
And as I understand it, let's set aside the jurisdictional complaints. You have several types of relief you're seeking. Some have to do with Mr. Carpenter, complaining that he didn't get notice of the injunction and that, or of this contempt proceedings. You admit that you have no right to be arguing on behalf of Mr. Carpenter on those issues, don't you?
Well,
No, you have, I mean, he's the person who has to bring those claims.
Well,
Isn't that correct?
No, Your Honor, and here's why, if I may expand on that, okay?
I'd be very interested. to
All
see
right.
if you can do that.
In order for the injunction to have been properly entered against Mr. Carpenter had to receive notice, not of the order, he had to receive notice before the order was entered, and that's clearly set forth in
Who's
the
the
law.
injured party on those things? It's Mr. Carpenter. You're arguing Mr. Carpenter's interest. You represented him in other things, I gather, so you'd like to help him, but not in this case. He has to be a party to this appeal for those issues to be before the court, does he not?
Well, but the problem then becomes this, Your Honor. If a party, it becomes the subject of an injunction order without the proper procedure, without being given actual honest-to-goodness service
Yeah.
of the motion that requests the injunctive relief, okay? Then who comes forward to ask the district court, please give this some more thought, because...
He does.
Well, why not why not
That's
why not the actual parties that are,
Because
to the
they're
extent
not,
they're there?
because they're not affected. If he's concerned about this injunction and he's bound by an injunction when he didn't get notice and so on, then he can seek a declaratory judgment. He can refuse to comply with the injunction and say, you can't hold me responsible to comply with the injunction because I wasn't properly served. I didn't get notice. Not some friend of his who says, gee, let's take care of this guy.
But it goes deeper than that, Your Honor, if I may. And the reason is this. Phoenix is already in the district court as an interested party, and it has an interest in not seeing injunctions entered without the rules of civil procedure being complied with.
It has
because
an
it's-
interest if it didn't get notice, or if it wasn't properly served, or if it's improperly named an injunction, it can do that. It can't complain about somebody else. That's their job.
But-
You're interested in it because you like the guy, and maybe he's paid you in the past. That is not the ground. And that's not a bad thing, but we don't have to listen to you in that circumstance. We shouldn't listen to you. We don't have a right to listen to you.
Well-
So I'm not going to pursue that anymore.
Okay. Would I?
You don't have an argument there. The only other relief you're seeking is with respect to double recovery. How is Phoenix affected by double recovery?
And if I may, Your Honor, here's the issue when it comes, and it's broader than just double recovery, because when we look at the 10th Circuit's recent opinion in Earthgrains Bakery, which we cited to, and when we look at the Alliance for Hippocratic Medicine opinion, that's the United States Supreme Court opinion, 602 U.S. 367, in particular, page 380, okay? When it comes to post-judgment orders, okay, non-parties with an interest are allowed to make appellate arguments. Having said that, and that is part of the one satisfaction issue as well, which the court is interested in.
I can see some merit there, if I can see what your interest is. And that's why I wanted to get to what you're seeking here.
All right.
You have no interest in, you have no legal interest in protecting Mr. Campbell with respect to the injunction. I can't see that. What is your interest with respect to double recovery? How is Phoenix being injured by your alleged double recovery?
Phoenix is being injured because the insurance policies are now owned by SDM Connecticut. SDM Connecticut is not a party to the civil proceeding in the district court. SDM Connecticut and the court has said interested parties regarding former SDM Oklahoma may appear as interested parties. As a owner of SDM Oklahoma, when it still existed, that is what has brought Phoenix to the court. And
the party that may have to pay more than it should because of improper double recovery is the LLC in
Yeah,
Connecticut.
where are they in this case?
Well, Your Honor,
Phoenix is not having to pay double recovery to anybody.
but the problem is, it is Phoenix's membership, and the district court has said interested parties may appear, so that's what we
That's
did.
fine. But the fact that you appeared doesn't mean you're interested. The fact that the judge allowed, he didn't let you intervene, but he heard from you. So you can make arguments. You're almost like an amicus. You're essentially an amicus, which is fine. But when you want to appeal the result and you're challenging double recovery, you've got to explain what your interest is in the double recovery. Then we can decide whether you're appropriately before us. I haven't heard.
And the interest is, these are post-judgment orders, and we fall within the scope of the United States Supreme Court case in Alliance for Hippocratic Court
In the scope
and
of
earthquakes.
anything until you identify the interest.
The interest
And
is,
how are you affected by double recovery? Just tell me that.
well, the interest is financial, Your Honor. These are assets of the Connecticut entity.
They're not assets of Phoenix.
Well, but Phoenix is a member, and there's no basis for the district court in Oklahoma having jurisdiction over the Connecticut
How many
entity.
other members are there of the?
I may be off by one, but I believe there are a total of 5 members, so there would be 4 others.
Okay.
So the problem is, you have a district court entering orders about assets that used to be the assets of an entity that clearly no longer exists, as part of a receivership over an entity, Avon, Wyoming, that clearly no longer exists, and you have an entity in Connecticut
That does exist.
That
and
does
could-
exist.
And could defend its interest by, the judge said, I'll let interested parties in. So the SDM, the LLC in Connecticut, I'm not going to try to get the name right. The LLC in Connecticut could come and appear as an interested party. There are other members. You could easily, as a member, you have enough influence, I'm sure, to get that company to try to participate as an interested party in Oklahoma, but that wasn't how you did it. You have Phoenix, and where?
But the problem becomes this then, Your Honor. It's a due process issue, because then the district court, through its actions, and this court, should it write an opinion consistent with the comments from the bench, is forcing a Connecticut entity to appear in Oklahoma when there is no minimum contacts, there are no claims actually against it, and I see I have run out of time.
well-
May I continue?
I'm going to
No.
make you continue. So it has, what was the last thing you said? Because it seemed to resolve the case. You said, if the LLC in Connecticut is not being ordered to pay money, is it?
Well, what has been,
Did the judgment in this case in district court order the Connecticut LLC to pay any money to anybody?
well, it ordered something else, the equivalent of that, which is it ordered that the Connecticut LLC's policies be sold. So it very much has a financial interest.
What do you mean by its policies?
Well,
Who owns those policies?
those policies are owned by SDM Holdings LLC, which is a Connecticut LLC.
And it's ordering those policies be sold to pay off the debts of?
A judgment against Avon, Wyoming, that was entered in the Western District of Oklahoma under an unpleaded alter ego theory.
So so it's being ordered as the Connecticut, I'll just say Connecticut LLC, is being ordered to sell some insurance policies and use the proceeds to pay Universitas. Is that right?
Well, just one aspect of it, I would put it in these terms. The district court in Oklahoma has ordered that the policies be sold
By whom?
by a manager who has been appointed, a manager of former SDM Oklahoma, who has in turn been appointed by the trustee over former Avon, Wyoming. So SDM Connecticut hasn't been ordered to sell its policies, but the court has ordered that the policies be sold.
And you're saying the Connecticut LLC can't It's not being ordered to do anything.
Its assets are being taken from it,
Well,
and it doesn't,
who
it shouldn't.
decides that it's their assets? Is that what they say? Apparently, it's being managed by somebody else. Somebody's turned over those assets. You know what? I'm taking too much of your time. Maybe I can get some clarification from opposing counsel. But I think to resolve things like subject matter jurisdiction, right to appeal and so on, we need to know what your interest is. I'm not learning very much what your interest is, what Phoenix's interest is in the judgment in this case. I know two of your claims are just for Mr. Carpenter, and you can't be representing him. So let me hear from the other.
Okay. May I respond very succinctly?
Yes.
In addition to the issues regarding Mr. Carpenter, I believe I've said this a couple of times, but I want to be very direct and try to be very succinct about something, if I may. The policies are owned by the LLC in Connecticut. Okay, and we know that because Avon, Wyoming doesn't exist, and SDM, Oklahoma doesn't exist, and there's the merger documents on file. So I don't know how else to put that, Your Honor, and my concern is that I'm not saying that with sufficient clarity, but that is very much the interest in the policies.
Your succinct time is over. So.
Thank you very much for your time.
I'd be very indebted if you can clarify these things for me.
May it please the court, your honors. My name is Joshua Greenhaw, I represent Universitas, the appellee. To the extent these questions can be clarified, this court has already done it. This court heard an appeal and issued an opinion December 31st, 2024 in case number 23-6125. I'll refer to that as the prior opinion.
Did it resolve the double payment issue? That's the only issue I think is possibly before us.
Since I was on the panel, I guess I would say no.
Yeah. It's kind of hard to say because I think, Judge Timkovich, I believe you wrote the opinion, and I don't want to quote your words back to you, but I think the other members of the panel may benefit just from hearing what you wrote when you considered these issues. The conclusion of the opinion, the prior opinion says, quote, "It is worth pausing to reflect on this case."
Yeah, I know what it said, but
Okay.
let's go to the legal issues here. I know this is the third installment of this saga, and that's unfortunate. But we need to focus on Judge Hartz's point is how Phoenix can object to a double recovery by SDM.
Yes, Your Honor. Well, let me take those one at a time. One is how can Phoenix object, and then I'll address the double recovery if that would be helpful.
Could you start with double recovery? Because to me, knowing what the issue is important to all the other issues.
Well, quite simply, there's not a double recovery.
What is alleged to be the?
What is alleged is that there is a prior settlement in another matter with a bank called WSFS. And there is a one satisfaction rule argument that appellant has made. That doctrine does not apply. There was a separate settlement and a separate cause of action against a separate party, WSFS, that occurred. That entity was not jointly and severally liable with any of the entities in this case. For
The separate tort or separate contract?
completely.
Can you tell us what it was?
Breach of fiduciary duty. The bank was acting as a trustee.
And a trustee in matters related to this litigation at all?
Tangentially related, yes.
So there was, and Universitas lost some money because of that entity's breach of fiduciary duty.
Yes.
Was it a breach of fiduciary duty in that the entity didn't protect it against these Campbell entities?
In part.
Well, then there could be overlap.
Well, I was under the,
Go ahead, Judge Achilles.
excuse me, I was under the impression that the one satisfaction rule didn't apply because the respondents were held jointly and severally liable, and the full amount of the judgment was not satisfied. Is that correct?
That's correct. The judgment debtors in this case were held jointly and severally liable.
With WSFS or whatever?
No, they're separate. The one satisfaction rule would be if I had a judgment, for example, against two tortfeasors, and they were jointly and severally liable, and I collected from 80% of the judgment from one of them, then I can only collect 20% of the judgment from the other one. That is not what is happening here, and our brief addresses that.
How much is the amount of that judgment that they're jointly and severally?
The WSF judgment?
No, the one in this case.
The one in this case, and I apologize, it's complicated, there's a $30 million underlying judgment, and then the judgment against Avon is $6.7 million, I believe.
And how much has been collected?
On the judgment in this case, the 6.7, I believe.
No, on the 30 million. How much was collected on the 30 million?
Approximately, and I apologize, I can't tell you off the top of my head. That information is in our brief in the record. I believe it's about, well, since my involvement in this case, we've collected about $600,000.
And who has to pay this? The argument here is that requiring payment of a judgment would result in double recovery for Universitas. Where is the money coming from that constitutes the alleged double payment?
The alleged double payment, what Appellant is saying? Yeah. From WSFS, I believe.
Well, that's not the judgment in this case. There's a judgment in this case for $6 million or $30 million or something.
The portion involved in this portion is $6.7 million.
Being ordered to pay that?
The Avon entities in this case.
And have they been ordered to pay it by selling their assets?
Judge Heaton appointed a receiver, and the receiver is attempting to collect the judgment, and it's a sale is possible, but that is one of several remedies that the receiver is pursuing, including paying the premiums on the policies and taking money from the policies as they pay out.
Does Phoenix have a financial interest in those policies?
Not to my knowledge, Your Honor.
Well, they said if they have a membership interest in Connecticut, why wouldn't they have some potential claim on Connecticut's assets?
The reason for my interest in the quote before highlighted the fact that there are shell companies and there is a shell game going on, and it is difficult to directly pin that down. I believe that the Connecticut entity could have intervened in this matter and chose not to.
I agree with that. And does this record, has Phoenix established anywhere in the record that it does have a financial interest? So far, I think all I've heard is the statements of counsel.
That's correct, Your Honor.
Is there any kind of documentary evidence, and maybe Mr. Sandberg could have a second to address that, but
I don't believe so, Your Honor. I've been involved in this case since approximately 2018, and Phoenix just sort of popped up one day.
And there are some helpful cases for non-parties, participating in an appeal. But I think they need to demonstrate that they're not just a friend of the court amicus, that they've affirmatively been harmed. And that's one of my frustrations here, is I haven't really seen that, because it's kind of hard to rule in this case if we don't know what's at stake.
Yes, Your Honor, I concur, and I've struggled with that as well.
But you,
Go ahead.
okay, but you
Well,
have
does
said,
Phoenix even have standing in this case?
I believe Phoenix does not have standing, Judge Kelly, that it's not a party. It did not file a motion to intervene. It could have sought to do so. In fact, Judge Heaton, in the case below, just recently declined to vacate one of his orders as requested by Phoenix because he found Phoenix did not have standing.
well, standing is
So we
particular
have
to
no
the claim.
jurisdiction and no standing.
But standing depends on what the claim is. So if, for example, they did own the insurance policies that were going to pay the judgment, and then they could have standing there. But I'm not sure what, all the judgment here does is require certain people to pay certain sums.
Yes, Your Honor.
Then there's a receivership proceeding where the receiver is trying to find a way to pay that judgment.
That's correct.
If Phoenix says you're trying to pay that judgment out of insurance policies that I have a financial interest in and you have no right to get to, then Phoenix could participate through the receivership proceedings. Is that correct?
It's the same proceeding, but it's
It's an ongoing thing, right? That's why I say the specific thing at stake determines whether they have standing. They have no standing to complain about the amount of the judgment.
I believe that's true, Your Honor.
This isn't an appeal from the receivership proceedings, is it?
It's just an appeal from the underlying case.
No underlying case. That's what's troubling me. We're speaking much too broadly. This is an appeal of the judgment to pay a certain amount of money. Then there are proceedings to find a way to pay that amount of money.
Yes.
Is that what this is? Is this an appeal from decisions regarding how to pay the judgment?
Yes, Your Honor, this is an appeal from decisions that Judge Heaton made to mechanically carry out his orders to pay the judgment.
Okay. So, and Phoenix's complaint is that the receiver has Judge Heaton approved anything by the receiver yet?
Yes.
And so Judge Heaton's judgment approves the receiver's decision that we need to sell these insurance policies.
Yes.
Is that correct?
Yes, and that was the subject of the prior opinion.
Okay. That was already decided?
Yes.
That the insurance policies could be sold?
Yes. And Phoenix was not a party to that proceeding either. Phoenix, it's instructive to note.
What has happened since our prior decision?
Your Honor.
There's got to be something new that they're appealing. What's new in the judgment of the order of Judge Heaton that wasn't resolved in the prior appeal?
From our perspective, nothing, Your Honor.
Well, I don't think SDM Connecticut existed, did it?
I'm sorry, Your Honor.
SDM Connecticut did not exist at the time of the prior appeal, did it?
I'm unclear. There are so many cases going on.
It's a successor to SDM Oklahoma, which is a successor to Avon, Wyoming, and I do recall that Avon, Wyoming was in the prior case.
Yes.
Was
Yes.
there any discussion in the prior litigation before this order, Judge Heaton? Any discussion about selling the insurance policies?
Before the orders that Phoenix is attempting to appeal today?
Yes.
Yes.
What I can see is if Phoenix is a member of an LLC that owns insurance policies that the judge has ordered to be sold to pay a judgment, then Phoenix might have an interest, might have enough interest for Article 3 standing. I still got a problem for a member of a LLC having the right to bring the case.
Yes, Your Honor. We've seen no evidence to support Phoenix's position. And in fact, if I may, Phoenix has put this note on a bunch of documents it's filed in the case. Quote, Phoenix does not consent to the jurisdiction of the court beyond Phoenix's compliance with the court's order, and Phoenix does not consent to jurisdiction of the court over Phoenix, i.e. Phoenix is filing this document solely as a, quote, interested party. It seems to be straddling the fence. I've never seen anything like it in my career, Your Honor. And
All right, well, to wrap things up, I think the best case that Phoenix has is a case called Plain on the interested party with a unique interest being able to appeal even if they were non-parties below. Can you distinguish that?
Are you talking about the Earthgrains case?
No, I'm talking about Plain, I don't have the full quote, Plain, 2002, 10th Circuit. Plain versus Murphy Family Farms, 10th Circuit, 2002.
Okay, Your Honor. I don't see that in the table of authorities for either of Phoenix's briefs in this matter. Perhaps we cited it. One moment.
Bottom line is you can't distinguish.
I'm sorry, Your Honor, I can't distinguish it right now.
Well, your time has expired.
Your Honors, thank you for the
One
opportunity
of
to
the
be
things
heard.
Oh, go ahead. Judge Kelly, do you have a question?
One of the things that's got to be shown, at least is my understanding, is that there's cause for their failure to have intervened. And I haven't heard anything on why they didn't file a motion to intervene.
Me neither, Your Honor.
Okay.
Thank you, Your Honors.
So case submitted, counsel excused. Court will be recessed until 8:30 tomorrow morning. Did I get that right?
Your Honor, did you want me to address the court's question?
You've had lots of chances to respond to questions.
Thank you.
So are you going to give me a call, Judge Hartz?
Well, we're going to conference in Judge Tibkovich's chambers, and we'll give you a call. How long?
Okay.
In 15 minutes or 10
Okay.
minutes? Okay, good.
Okay, that's fine.
Thank you.
Court is at recess until 8:30.